but I assume that the respondents and the applicants are able to hear me. Can the applicants please just confirm? Please switch on your audio and confirm that you do hear me. Applicants? Justice Somo, are you in attendance?
Yes, Justice Toga, I'm in attendance.
Are you aware of the whereabouts of Justice Kaba?
Unfortunately not.
Okay.
Ma'am?
Yes,
Hello,
I'm speaking to.
Sunrise V Secondary, the respondents. Are we in the right courtroom?
I'm checking my schedule just now for that. Yeah, courtroom B, 224 respondents, and then I'm expecting 137 applicants, but there's a high school here in the room who's not labeled appropriately and they have not said who they are. Please, can the applicants or Freedomburg High School that appears here, please just confirm that you are online and that you do hear us. Justice Klaba? Justice Klaba?
Good morning, everyone. My apologies. I'm just experiencing some connectivity issues.
Okay.
Sorry for my late joining, and I'm not steady yet, so apologies if it's gonna take me in and out of the call, but hopefully we won't experience that. But apologies.
No problem, Justice. Thank you very much for joining us. And thank you for advising us on your technical issues. I am still looking for the applicants to confirm that they're in attendance. Freedomburg High School, are you the applicants? Freedomburg High School. Submit. Nelsie Foodie, kindly confirm your identity, please. Nelsie Foodie. Nelsie Foodie.
I am here.
You are, who are you, ma'am?
I am Nelsie Foodie, the educator from Sunrise View Secondary.
Who is this? Is this the respondent? Is this the applicant?
Respondent.
Respondent, okay. Thank you.
Yes.
Okay, thank you very much. Freedomburg High School, we are waiting on you. You are the applicant. You would be expected to start. If you do not start, you will be disqualified and will allow the respondents to proceed with the session.
I don't know where are there any chance contact details for them? I I'm assuming they're probably experiencing some technical issues on their side as well. I don't know, is there any way of, quickly contacting them or something of that sort? I don't know.
Let me
'Cause,
just try to get into contact with the coordinator, Mr. Mtsweni.
Okay. Okay. Thanks.
Mm. Friedenberg has again. Yes, Justice Klaba.
No, I was just thinking it would be very sore on their part if we were
I know.
just without making some kind of an effort. But I think yeah, we can attempt for the next 5 or so minutes, and then we can see what happens after that. If
Okay.
if everybody agrees.
Okay. I just obtained confirmation from Mr. Matthias that
Okay.
we would start at 9 today.
Okay.
So I'm just
Oh,
asking him to nudge them so that they can appear.
Oh, okay. Okay, no, not a problem. Not a problem.
So that if they are indeed having technical difficulties like you faced earlier, we are able to confirm all of this and able to make some sort of alternative available if it means to do that.
Okay. If we're meant to start at 9, then I think we probably got a couple of minutes still.
Yes.
Thanks for that. Thanks.
Thank you very much. So we will recommence in this room at 9 o'clock sharp.
Okay. Excellent. Thanks.
Thank
Yeah, I'm ready on my side, and we've got two.
Yes, I
I'm saying
can.
yes, we had 224 for the respondents, right? And then I assume the 137 is for the applicants.
Correct.
Is am I correct?
Excellent.
Okay.
Yeah.
And that's Papir start. Okay.
Yes.
Oh, good morning, Your Justices. My name is Rutanan Reichardt.
Please say that again.
My name is Rutanan Reichardt.
Rutanang Reichardt. Yes.
Your Justices, my name is Rutanan Reichardt, and together with my co-counsel, of the court
Please kindly pause, applicants. I just want to confirm from the justices that they do hear you. Do you hear them, Justice Somo, Justice Kaba?
Justice Tonka, they all keep coming in and out. It's very unclear.
Okay. I don't know if it's possible for the applicants to maybe, I don't know if it's to stand still or to do, I don't know what. To sort of ensure that we are able to hear you.
So they
Please just try again, Ms. Rutanang Reichardt.
Your Justices, can you hear me?
Yes. Yes, I do.
So may I
Kindly proceed.
proceed?
Yes, please.
Yes. Sorry, Ms. Reichardt, if you can start by introducing your colleague as well, the other counsel, so that we have their name as well. Can you do that?
Yes, I can do that. So may I?
Ms. Reichardt?
Yes, ma'am.
Yes, kindly introduce your co-counsel.
My co-counsel's name is Toby Umakai.
Tobile who?
Umakai.
Tomagai.
Should I spell the surname for you, ma'am?
We-
Tomakai, Comakae.
AE. Okay. So it was less about the pronunciation or spelling of the name and more about me just not being able to hear you because of the audio
Yeah.
issues. But however, please do proceed. Do you want to reserve 3 minutes for rebuttal?
Okay, thank you, ma'am.
Do you want to reserve
May I
3 minutes
proceed?
for rebuttal? Yes, you may proceed, but I'm asking, do you want to reserve your 3 minutes rebuttal time?
Yes, ma'am.
Remember, I
Yes.
told you have to be very intentional about that 3 minutes because it's the difference. But anyway, yeah, kindly proceed. This is 17 minutes, Mr. Kaba, that we're going to give to them to speak.
Yes, I'm with you, Justice.
Thank you.
Issue-
Proceed, applicants.
My co-counsel, we are counsel. My co-counsel will also be taking 9 minutes of the court's time, and I will be addressing the court on the first issue on rights to privacy and the right to basic issue on why the SG violates the right to of the Constitution of the respondent. Your Justices, Section 4 of the School's Code of Conduct states that use of cell phones, whether on or off, is phones confiscated and may force suspension. 6 cell phones were found switched off when the principal ordered for a search of the bags of the learners. These learners were immediately suspended from the school for the rest of the year. What this tells us is that they were not allowed to attend any classes as of immediate effect. They were therefore denied their precious right to education by the SGB. Hence, rights to privacy and basic education have been violated because of the following reasons. A, the applicants were suspended for a full year, their bags were seized, and their private communication through WhatsApp text was invaded by the police. The Constitution of South Africa, as the primary source, provides in Section 14 that everyone has the right to privacy, which includes the right not to have their home searched, their property searched, their possessions seized, or the privacy of their own communication infringed. Furthermore, Section 29 provides that everyone has the right to a basic education, including adult basic education, and to be further education, which states through reasonable measures must make progressively the code of conduct that was adopted and implemented with immediate effect. We submit that it was unsuitable and unprincipled. It didn't follow a reason that in terms of South Africa 96, Section 8 of the Code of Conduct, Section 1B states that subject must adopt a code of conduct for the learners after consultation with learners, parents, and educators of the school. Moving along with subsection 2, states that a code of conducting a disciplined and purposeful school environment dedicated to improvement and maintenance mission to use a consultation consultation process. First, the implementation of the code of conduct was on an accurate consultation process. Then Mrs. Khoza would not have threatened the learners after CSOT's suspension with immediate effect. And second, would not have texted the parents of all learners in school, telling them that if a mistake has been made, a way forward must be found. And this, on these confirmations, we submit that it is clear that the educator component of the SGB, along with Mrs. Khoza, the new principal, made the decision, the code of conduct, exclusively. Moreover, as the Act stated in subsection 2, we submit that section 4 of the work in a group or project sharing it again in a format they are comfortable with a whole year.
Sorry, Ms. Reichardt. I think can I please ask that you, if you're able to, can you repeat that last point, the last score that you made? I battled to hear you for I think for at least 20 seconds there, and I think that was important. Can I please ask that you repeat that score again? Can you hear me? I think we've lost you now.
Possession for the cell phones.
Am I the only one, justices? Am I the only one battling?
No, it's painful to listen
No,
to.
it's not.
Yeah, I followed her when she for the
Yes.
major part, I think, of her first
Yes.
point. But
Yes.
I'm battling her, and I think she was making important comments there.
Mm.
I think let's try again. Are you, Ms. Reichardt? Are you there? Oh goodness.
Ms. Reichardt? Ms. Reichardt?
You're just saying.
We are unable to hear you, ma'am.
Can you now hear me? You're just.
We hear you a little bit now, but for the last 30 to 45 seconds, we could not hear a word. We're really struggling to follow.
Should I repeat what I just said, Your Justices?
Please, kindly.
Yes, please. We got the first score that relates to the school having made the code of conduct, exclusively, and I think you were on to the next pointers. I think that's when we really battled to hear you. I think if you can continue from that score, that would be great.
Okay, sir. The matter where the applicants were suspended for a period of a whole year for simply being in possession of their cell phones at school. Therefore, counsel for the 1996, Section 8 of Code of Conduct and Section 9, suspension and expulsion from public school, subsection 1A of the same Act states that subsection 6 of Section 8 A learner must be accompanied by the parent at a disciplinary hearing or proceeding unless good cause is shown by the governing body for the continuation of the proceeding in the absence of the parent. After a fair hearing suspends a learner from your justices, along with Section 1A of Section 9 states that subject to this act and any provincial law, the governing body of a public school may, after a fair hearing, suspend a learner from attending the school as a correctional measure for a period not to Mrs. Costa's firm rules, as it was a line of attack to bring in discipline back to the school. She announced that learners are going to be punished for small transgressions and teachers are going to apply corporal punishment without being reprimanded, even when it is illegal. Counsel for the Section 10, prohibition of corporal punishment, subsection 1 and 2 states that no person may administer corporal punishment at a school to a learner. And any person who contravenes subsection 1 is guilty of an offense and liable of conviction to a sentence which could be imposed for assault.
Just pause for 2 seconds. Ms. Reichardt, just 2 seconds. Okay, proceed. We could not hear you.
So should I repeat the
Yes.
sentence again,
Yes,
ma'am?
please. Yes,
Many
please.
learners
Yes,
at
please.
Mjondolo did stage a protest against Mrs. Koza's firm rules around freestanding outside school with posters denouncing the ban of cell phones, the use of corporal punishment, Koza the cause of this, and free speech. This also that if it was not for Mrs. Koza, the school would have been on good terms. Therefore, Mrs. Koza's firm rules simply led to bad publicity all around South Africa, and thus enjoined his or her child to attend. In addition to what I've just said,
Sorry,
ma'am,
counsel.
your justice, sorry,
Look, the school
your
already
justice
had
is
a
in
bad.
addition to what I've just, ma'am,
Counsel,
your justice,
can you hear me?
I can hear you, your justices.
Counsel, so I just have a question. The school already had a bad reputation. This bad reputation wasn't just caused by the principal, as you're alleging. There was already absenteeism. Pupils were not passing. Teachers and pupils were not attending school. And then here comes a principal who's actually trying to enforce discipline. How is that a bad thing?
Okay, can I have 1 minute, ma'am?
Yes, you can. Just before you respond,
May you please?
just before you respond, Counsel, just we are out of your 17 minutes that you were allocated for. But I think because of the connectivity challenges, I think we'll be happy if my colleagues agree to perhaps give you I think a 2-minute indulgence. So you have 2 minutes to respond to that, and yeah, and maybe sum up your arguments. But you will give you a minute to respond to my colleague. I think posed question there. Thanks.
May I get the question again, sir?
So, counsel, my question is, this school already had bad publicity due to the fact that students were not passing, people and learners were not even attending the school. And here comes a principal who's trying to enforce discipline. How are you trying to pin any kind of bad publicity on the principal right now?
The principal, when the principal entered the school years, the percentage went from 53% to 72. That is correct, ma'am. But
So then, Council, wouldn't you agree that this principal is actually trying to give the school good publicity by enforcing discipline? Council, did you hear my question?
trying to get the right to basic. I heard your question, ma'am.
Council, have you provided us with an answer?
What's your response, Council, to the question?
I was saying that I agree that the
Council, I think if you switch off your video, perhaps you might get better connectivity.
principal 52. Switch off.
I think just try switching off your camera. The connectivity might be a bit better.
Yes, ma'am. Can you hear me, ma'am?
Yes, I can hear you.
What I'm saying is, yes, the percentage went from 53 to 72%, but that doesn't allow Mrs. Koza to she wanted to make the school a better, stay in school and use other punishments instead of spending them for the whole year and applying corporal punishment.
Thank you, Council.
Yes. So I mean, what's your response? Is that I'm struggling to relate that to the question posed. But if my colleague is happy with the response, then I think we can move on. But I don't think that the question was answered there, because the question was in relation to the reputation. My colleague said the school already had a bad reputation, because your argument was that Ms. Koza has brought the school into disrepute, and bad reputation came with it. And then my colleague said, but this the school already had a bad reputation, and Ms. Koza is trying to improve that. So I don't know whether the question, your answer spoke to that aspect of reputation. But if my colleague is satisfied with what you've provided us, then I think we can move on.
Okay. Just for purposes of time and not keeping the session going for too long, in the interest of the people in the session that follow, can we kindly proceed to the respondents, please?
Yeah, we can.
Respondents, kindly present yourselves.
Honorable Justices, I am Papanomaje with my co-counsel Penny Mutiba.
Please say that again.
I am Papanomaje with my co-counsel Penny Mutiba.
Okay, thank you very much. Kindly do proceed. I assume that Justice Baba is keeping time.
Honorable Justice, as I said, I'm Papanomaje and here with my co-counsel Penny Mutiba, appealing on behalf of the respondent. I will be speaking 8 minutes and will address the court on how the respondent's code of conduct does not violate the applicant's right in terms of sections 14 and 29 of the Constitution. And my co-counsel will speak of how the applicant's rights in terms of section 17 of the Constitution were violated by the respondent. Were not violated by the respondent. My justices, my co-counsel will speak 9 minutes and reserve 3 minutes for rebuttal. If it pleases the court, counsel wishes to continue with his rebuttal. My justices, we begin by referring to the process that occurred
Pardon, counsel, I'm so sorry to interrupt you. Just to the fellow justices, I just want to confirm that the second speaker for the applicant did not speak. Is that correct? I just want to confirm that.
I think that is correct.
Thank you.
I believe that to be correct unless they're able to tell us otherwise. Respondents, kindly do proceed.
My justices, we refer to the process that occurred preceding the introduction of the Code of Conduct. It is stated in the case study, after a consultative process, the SGB decides to introduce a code of conduct for the learners, regulating the use of cell phones. Counsel for respondent emphasizes the words after a consultative process, which mean that more than one consultation occurred and for a period of time. This makes the Section 4 constitutional in terms of Section 8, subsection 1 of the South African Schools Act number 84 of 1996, which states that subject to any applicable provincial law, the governing body of a public school must adopt a code of conduct for the learners after consultation with the learners, parents, and teachers of the school. Is this not what is meant by after a consultative process? Certainly the learners...
Respondent, can I please just intercept? Nothing in the facts specifically stipulates that the consultative process included everybody, including the children. And from the children's response, I think it is reasonably, it can be reasonably assumed that they were not part of that process.
Well, my justices, in reference to that, we have done our research and found out the definition of a consultative process. According to Law Insider, a consultative process is a good faith dialogue, an open good faith dialogue among the appropriate individuals designated or identified by each party on breaches, disputes, or issues of concern to or affecting the collaborative.
Counsel, I hear you, but I am saying that the way that the children responded to this code of conduct regarding the phone, or this code of conduct rule regarding the phone, clearly shows us that they were not consulted, because if they had been consulted, they would have made their position known or they would have adhered. And clearly they were not aware of it when you look at the immediate next paragraph to that. So, but anyway, just proceed with your argument.
My justice is, surely the learners knew about the new rule. And if they did not know, could they not have protested against that instead of only protesting after bearing the consequences? Counsel for respondent submits that the applicant only opposes this rule because of opinion and emotion rather than fact. It is illogical, my justices, to disobey a rule and when punished say that it is unconstitutional. This is the case of the applicant. Counsel for respondent therefore contends that the code of conduct is constitutional as all necessary procedures were followed in implementing it. If it pleases the court, we submit that it is stated that everyone has rights. Yes, Justice.
In order for a rule to be regarded as constitutional, you're not just looking at the procedural requirements, right? You're also looking at the substantive nature of that particular rule. Now, going through all of the requirements of Section 36, how would you justify that this rule is constitutional, especially then giving consideration to the right to basic education, the best interest of the child, and the fact that there are less restrictive means to actually impose discipline or enforce discipline in this particular school?
My justice, that's my next point, if you will allow me to continue.
Yes, please continue, Counsel.
Well, in considering this, the respondent does not violate the applicant's rights, but rather limits them. We note in Section 36, subsection 1A and B, that it is stated that the rights in the Bill of Rights may be limited to the extent that it is justifiable and reasonable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors, including A, the importance, the nature of the right, and B, the importance of the purpose of the limitation. Surely the court must agree that the academic success of the learners to be of paramount importance, as it will ultimately cater for the nation in future. Was not the code of conduct introduced for the education of the learners and the improvement of the quality of the learning process? The court must notice that the respondent acts in accordance with Section 8, subsection 2 of the South African Police Act.
We do agree that the education of the learners is quite important. And really what we're arguing, or at least what I'm trying to ask you, is this particular rule is actually infringing on those learners' right to education. And there are less restrictive means to ensure that, number one, this right to education is given effect. And then number two, that discipline is in fact enforced in this particular school.
Yes, it just.
Sorry, Mr. Major, before you continue, I heard you initially saying you'll run your argument or your arguments for 8 minutes. You have 2 minutes left of that 1 minute of that 8 minutes now with the 1 minute indulgence from our side. So you got 2 minutes to proceed with the arguments. Thanks.
Okay, your justices. May I continue?
Yes, please.
Yes, you may. Yes, you may. Thanks.
All my justices, we do agree that there are less restrictive means in terms of suspension. My justices, our main argument is that the learners were notified not to come with these cell phones at school. And certainly they all knew about it, considering that only these 6 learners out of substantial amount of learners came with their cell phones to school, if it answers your justice's question.
No, Councillor, it doesn't, because you are dealing with minor children here. And for them to transgress such, I don't want to say simple rule, but really a simple transgression, and then for the punishment to be so harsh so as to violate their right to basic education, would you say that that is fair in a democratic society, in a constitutional society?
Well, my justice, in reference to that, we do emphasize that the learners were warned before, as stated in the case study, that Mrs. Khoza warns that as from the next day, all cell phones on or off will be confiscated, and those who are defying the ban will be suspended with immediate effect.
And yes, so Council, I'm not arguing the fact that they were not warned. I'm not arguing the fact that they need to be punished, but we're saying that the punishment is too harsh for the particular transgression.
Yes, it is.
Council,
Yes.
do you think that there was a less restrictive, do you think that there was a less restrictive punishment that could have been meted out to these children? And if so, what do you think that is on behalf of your clients?
Yes, justices. The less restrictive means would be just maybe to suspend the learner after a disciplinary hearing for at least 7 days.
Okay. So do you concede then that that particular punishment unnecessarily infringes on the child's right to an education?
Yes, just.
Okay, kindly proceed. If you still have time, Justice Baba, advise.
Mr. Major, your time is up now. That's including the minutes. We've made now 2 minutes indulgence that came just from our side, but your time and including that is up now.
Okay, thank you. Do we still have the 3 minutes for the applicant's rebuttal?
Yes.
Applicants? Applicants?
Yes, so justices, we have a submission for the rebuttals.
Okay, please proceed.
Your justices, I hear that there is no consultation process. If there was an implementation of consultation process,
Applicant.
Yes, your justices.
I don't know, my fellow justices, can you please just confirm? I'm not hearing anything.
No, they are completely inaudible, Chief Justice.
Sure. Okay. Okay, let's just see what we can do in the next.
Chief Justice, can you hear me?
Ever so slightly right now, but ordinarily no.
I'm more audible now.
Yes, please proceed. We'll hear what we hear in the next 3 minutes if we hear anything.
Your Justices, as I was saying, that in matters of that, the respondent said that there was a consultation process. Well, I'd like to plead that there was no consultation process. That Mrs. Koza would have not threatened the learners after suspension, telling them that whoever defies the ban will be suspended with immediate effect. Therefore, we should know that the individual knew of this code of conduct, and not every individual saw the need for this code of conduct. So,
Chief,
not the
Chief
process.
sorry,
Justice
sorry.
Kaba?
Yes, CJ, the 3 minutes is up now, so I don't know if you want to indulge.
We don't have any time for indulgence right now
Okay.
because other colleagues are waiting for us to exit this room so that they can exit. I'll just hear final comments from the honorable justices to the different teams. Justice Somo?
Chief Justice, I just say my comment is that it's quite unfortunate that we had such great difficulties just hearing the applicant, because really I think I heard very, very little from the applicant, which was audible. And then, because of that, it's very unfortunate that we didn't get to hear the other two speakers. But from what we did hear, we appreciate all the attempts made by the students to put forth their arguments.
Thank you very much, Justice Somo. Justice Kaba?
Just to echo those sentiments. And I think in relation to the respondents, my understanding was because I judged Mr. Maja on the basis of the fact that he said he would speak for 8 minutes.
Yes.
And then the colleague would come thereafter, and I think he was well on time, and I thought that there was a bit of time for Mr. Mutiba to make his presentation. So I think to a certain extent, I think we cut them short there. But at this point in time, I think I'm happy with what they've presented. So no further comment on my side.
Chief Justice, sorry, if I might just add one thing.
Yes,
I would just like you to tell counsel for the respondent, do not concede your points. There are multiple arguments that you can make, and the moment you say you concede, that becomes very problematic for your client.
You've thrown in the towel. Do not throw in the towel. Hold on to that little thread. Even if you see that you're holding on to nothing, pull on it.
Yes, so go through the requirements of Section 36. Tell us how your client has met those requirements. Use the law. You have an abundance of case law of sections to try and support your point, but do not concede.
Yes. And then with respect to the applicants on my side, the little that I did here, especially in the beginning, I was extremely happy. It was extremely nuanced. It went into the many different aspects of the right to basic education for children. So in my career, I am a child law specialist. So to hear that level of specificity from a high school learner. These are things that in ordinary practice, I don't even hear when I go to court and we're listening to arguments being presented by other counsel on behalf of the state, for example. But the fact that you were able to go as deep as you did, I was very, very happy to hear that, applicants. I'm just upset that the connection was what it was, and we were unable to hear the rest of your submissions quite properly. But with the little that I heard, I was extremely impressed, ma'am. And then with the respondents, you spoke very well. You held your own, but when I came and I asked you those other questions, you began to concede. And don't concede. Moving forward, don't concede. As I said, don't throw in the towel. Even if you don't really have the towel and you just have a single thread, hold on to that. As my learned colleague, Justice Somo, also told you, just go through the different requirements of Section 36 of the Constitution, and then you will be able to see how you can tackle those kinds of questions, because you will see them as we go forward from other justices as well. So thank you to everybody who participated. Thank you to everybody who came to support the children in the different rooms. We are about to exit the room. The justices and myself will make the necessary administrative submissions to Mr. Matthias, and I wish you luck going forward in the competition. Thank you.
the case from the respondents.
Okay. Okay. As it pleases the court, I am Zina Rooms here with my co-counsel, Ms. Nsmcc, and we will be representing the respondent. I'll be speaking first for 12 minutes to address issue 1 and 2, which is the alleged violation of sections 14 and 29 of the Constitution based on section 4 of the School Code of Conduct. My co-counsel will be speaking for another 8 minutes to address section 17 of the Constitution and how the school governing body's decision does not violate this right, and to conclude. Would the court find a brief summary of the facts helpful?
Yes, counsel, please proceed.
In early 2019, a code of conduct was adopted by the school governing body of Njondolo Combined School, which led to the suspension of 6 learners for the possession of cell phones on school premises. The question before the court is whether Njondolo Combined School violated the learners' rights to privacy and basic education in terms of sections 14 and 29 of the Constitution. The second question is whether the school governing body's decision to suspend the learners for the possession of cell phones is unconstitutional and violates the rights of peaceful assembly in terms of section 17 of the Constitution. In response to these questions, we, as counsel for the respondent, will prove why none of these decisions are unconstitutional. If it pleases the court, I will now continue to address the first 3 issues. Turning to the first issue, which is whether section 4 of the School Code of Conduct is unconstitutional. Njondolo Combined School added this new rule to prohibit the use of cell phones on school premises. Any learner found with one will have it confiscated. The respondent disagrees with the applicant's charge that the School Code of Conduct is unconstitutional. It is a well-known fact that learners all around the world use every opportunity to be on their cell phones. Thus, they are constantly on social media during lessons, making it difficult for the educator to teach. Section 8.2 of the South African Schools Act states that a code of conduct should be aimed at establishing a disciplined school environment, and we agree that the rule put in place aimed to create a focused classroom environment and was thus successful.
Just to interject the council, please note that you are allowed 20 minutes to speak, and each speaker may not speak more than 10 minutes, if I'm not mistaken. So just be cognizant that we are keeping time.
Yes, Justice, we understand.
You may proceed.
Cognizant of Section 36 of the Constitution, we argue that for the learners to receive their deserving education, that the Code of Conduct must project this harsh punishment of suspension, because the only way the school could have the learners follow the rule is for the punishment to be consequent. The respondent does acknowledge that all rights in the Bill of Rights can be limited according to Section 36(1)(e) of the Constitution. But my client believes that this was the best option, as the school is a place where you learn valuable lessons and self-discipline. Less restrictive means could have been used to project this punishment, and I will consult my client about that. But the learners are at an appropriate age to understand that all the actions have consequences, no matter how severe they are. It is clear that the respondent was only working in the best interest of the learner.
Counsel, do you believe that there may have been less restrictive means with which to accomplish order in a classroom, as opposed to confiscation and suspension of students?
Yes, Justice, there could have been more reasonable means that my client could have used to address the issue of cell phones in class.
Do you then maintain that the Code of Conduct is not unconstitutional?
I do still maintain that the School Code of Conduct is not unconstitutional.
Just to understand you correctly, counsel, so you concede that the way other less restrictive in which the school. Okay.
Yes, Justice. The respondent was only working in the best interest of the learners. They were being disobedient, and these measures had to be enforced to ensure that no one's future would be negatively affected. Counsel for the respondent hereby submits that Section 4 of the School Code of Conduct is not unconstitutional. If there are no further questions on the first submission, I'll proceed to address the second issue, which is the supposed violation of Section 14, which is the right to privacy of the Constitution. Excuse me, I'm just going to drink some water. Section 14 of the Constitution states that everyone has the right to privacy. A learner dropped his cell phone in class and it was confiscated. He had a disciplinary hearing which resulted in his suspension. Ms. Koza realized that the learners might not have been following the new rule and ordered a search of the bags. The applicant may argue that this is an infringement of their right to privacy. The counsel for the respondent argues that this was justified. Ms. Koza had a reasonable suspicion and was allowed to search any learner. 6 learners brought their cell phones and were suspended. The same could be said had it been an illegal weapon or substance, as these are forbidden items in our country, like the cell phones are forbidden items on the school. Therefore, the respondent did not violate the learner's rights to privacy, and it is clear that the applicants were not following Section 4 of the Code of Conduct. Our honorable friends also argue that the privacy of Eddie's communication was violated, thereby degrading his human dignity. We submit that this is not true, as the Criminal Procedure Act allows any policeman to search any person without a search warrant. They, of course, have to have a reasonable suspicion, and if Eddie aided in the first protest, the police could have been suspicious that Eddie was involved this time. Therefore, his cell phone was searched and his text to in Bali and crystal was found. It is clear that his rights to privacy and human dignity was not infringed, as the police did not randomly search him. They had suspicion that searching him would turn up valid evidence and that he was somehow involved with the gathering this time. Your Justices, that concludes my second submission, and if there are no questions, I shall now proceed with my third submission, which is the alleged violation of the learner's rights to basic education in accordance with Section 4 of the School Code of Conduct. Once again, a protest of which no notice was given was held with approximately 100 learners contravening Section 3.2 of the Regulation of Gatherings Act. These learners had posters degrading Ms. Koza's name, violating Section 10 of the Constitution, her human dignity. The learners were also blocking the entrance to the gate during the protest, making it difficult for other learners to receive their right to education. We can believe that they were the ones violating Section 29 of the Constitution. A fire was started in the administration building, and Tatu, Precious, and Apiwe were arrested as they were the ones leading the protest the day before. Although no culprits were identified at the scene, we can say that it was circumstantial evidence that led to their arrest. These learners held an illegal gathering because they felt that their suspension was unfair. So we can assume with intent, one of them set the administration building on fire. This is the only reasonable explanation based on the circumstantial evidence, Your Justices. If there are no questions, I'll now be handing over to my co-counsel who will address the final issue.
As it pleases the court, I am Nsmcc, and I have allocated myself 8 minutes of this honorable court's time to address the final issue, which is the alleged or the supposed violation of Section 17 of the Constitution. The 6 learners say that the school governing body decision was unconstitutional as they were only exercising their right to peaceful assembly, and they do not feel that their right should have any restrictions. Yes, we as the respondent acknowledge that, but according to the United Nations Convention on the Rights of the Child, Article 15, 1 and 2, it states, states parties recognize the right of the child to freedom of association and to freedom of peaceful assembly. No restrictions may be placed on the exercise of these rights other than those imposed in conformity with the law and which are necessary in a democratic society in the interest of national security or public safety, public order, which is what the school is trying to achieve, the protection of public health or morals, or the protection of the rights and freedom of others, which is what the learners infringed as they were stopping the rest of the learners from getting their own education. These learners did not only go against Section 3 of the Regulation of the Gatherings Act, they also went against the law that says a protest has to be peaceful and no violence is to be used. Paragraph 53 of the Harvard case says that when the person who has the right to peaceful assembly has no intention of acting peacefully, that they lose their constitutional protection. And at the protest that they arranged, things could have gone terribly wrong when the ban was set alight. Therefore, the school governing body's decision to suspend them is not unconstitutional. Their right to peaceful assembly, in terms of Section 17, did no longer protect them.
Just to interject, Council, you are saying that the school's decision to suspend them is not unconstitutional. Okay, but what about the sanction which the school imposed on them? Don't you think that the sanction infringes on the students' rights to basic education?
I'm sorry, Your Justice, I did not get the question. Could you please repeat?
Can you please repeat that?
I did not get your question, Your Justice. Could you please repeat it?
Oh, yes. Okay. So I am saying, I understand that you say that the school's decision to suspend was not unconstitutional, but I am saying that I'm more concerned with the sanction or the punishment the school imposed on the students who were protesting. So I am saying that don't you think that the sanction is too harsh and infringes on the students' right to education?
Your Justices, the principal did try to arrange a meeting with the parents of these learners in order to discuss this protest. I believe if the learners actually allowed that meeting to take place, we could have been able to find a solution which would be not suspending them, but instead they organized a protest which stopped that meeting. So the school found it fit, or they found this was the best possible solution in order to suspend them, as this was actually stated in the Section 4 of the school's code of conduct.
Okay, Council, you may proceed.
Sorry, just an interjection from my side. What about the length of the suspension on the learners? Do you think that there's a justifiable reason why it should be 6 months as opposed to the 3 months period provided for in the Schools Act?
I'm sorry, I did not get that question.
All right. So in the Schools Act, it does not recommend for suspension longer than 3 months, but the learners in this case have been suspended for 6 months. Do you think that there is a justifiable reason for the school to elect to suspend them for 6 months?
I am sorry, Your Justices. In the facts or in the resources that we received, it did not state for how long the learners were suspended for. It just said for the maximum period. So I'm not sure if it was 6 months or 3 months.
All right. Thank you, Council.
It is justifiable that each of the learners were arrested and detained in Section 12(1)(a) of the Gatherings Act that states that any person who convenes a planned gathering in respect of which no notice was given shall be guilty of an offence and shall be held criminally liable, and in case of a contravention referred to in paragraphs A to J, a fine may be issued. If there are no further questions on this submission, I will now proceed to summarize our arguments and to conclude. In summation of our arguments, counsel for the respondent has established that the respondent did not violate the applicant's right to basic education.
You have 4 minutes left, Council. You have 4 minutes left on your overall time. 4 minutes left.
Yes, Justice. You can go on. In terms of Section 14, 29, and 17 of the Constitution, counsel for the respondent respectfully requests this Honorable Court to declare that the High Court was correct in ruling in the school governing body's favor, as the respondent has violated no rights of the applicant. And in this case, a fine is appropriate for dealing with this matter, as the school's property was also damaged during this protest. That is all the respondent has argued, and thank you.
Are there any questions from your side, Justice Shanga?
I have no further questions.
All right. Thank you very much for your submissions. I will direct my feedback in the score sheet. I would just like to compliment both of you on a very confident and clear presentation. And I wish you luck for the upcoming rounds. And as also I'll speak for your use of international law in your argument. It's very well done.
Thank you, Justice.
All right, then I think the session has come to an end. Okay. Thank you very much.
Thank you.
Bye.
I believe that now both teams are here. Yes, so we have team 105, which is applicant, and team 119, which is the respondent. Respondents, you are late, but nevertheless, we'll just continue. Yes, so now we are like 7 minutes behind, but that's not a train smash, we'll continue. So I am Justice Shangi, I will be the anchor judge for this session. Together with me are my colleagues, Justice Olivier and Justice Thomas. So yes, they will just introduce themselves briefly. Thereafter, I will allow the teams to also introduce themselves. And then please note that each team is allowed to speak for a maximum of 20 minutes each, of which one speaker may not speak more than 10 minutes. And the applicant is also allowed to reserve 3 minutes for rebuttals if they wish to do so, and they should indicate that in the beginning. So I'll just allow my colleagues to introduce themselves, and then we'll commence briefly. Colleagues, please introduce yourselves.
Hi, I am Shiri Wilifir, and I will be sitting in as a judge today.
Good morning, Council. Craig Thomas, and I will also be justice today.
Okay, thank you very much. Applicant, please introduce yourself. And also just give us your names so that we can write down your names.
As the court pleases, I am Makgotso Motshwane. I'm with my co-counsel, Masiso Tladi. I'll be speaking for 10 minutes. My co-counsel will be speaking for 8 minutes and reserve 2 minutes for rebuttals. Okay,
so just before we commence, may I please just ask Justice Olivier to to be the timekeeper for us? And yes, okay, so the first speaker for the applicant, what is your name?
Makgotso, as the court pleases, my name is Makgotso Motshwane.
Okay, Makgotso is in M-A-K-O. It's M-A-K-G-O-T-S-O, correct?
No, it's M-A-K-H-O-T-S-O.
M-A-K-H-O, okay, yes. M-A-K-H-O-T-S-O. That's the first speaker for the applicant. And then the second speaker?
Masiso Tladi.
Second speaker for the applicant, please introduce yourself.
As the court pleases, I am Masiso Tladi, and I'll be appearing on behalf of the applicant.
Please just spell your name,
M-A-T-H-T-S-H-E-D-I-S-O.
Okay, so I just want to address the text there from team 119. Team 119, I checked the schedule and you are supposed to be against team 105. So yes, that's not a problem. So yes, applicant, please comment with your argument, and then because now we are running we are running behind schedule, and then team respondent will also introduce themselves when it's their time to present their case. Applicant, please take it away.
Your Justice, as the court pleases, in this case, I'll be focusing on issue 1, which is the constitutionality of section 4. I'll be submitting to this honorable court that it is unconstitutional as it violated learners' right to education, which is section 29 of the Constitution. And I'll also be proving to the court that in its application, it has violated learners' right to privacy in terms of section 14 of the Constitution. Your Justice, my co-counsel will be submitting to this court issue 2, which is the constitutionality of the SGB's decision. She will show the court that it was unconstitutional as it violated the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. As the court pleases, would Justice like to have a brief summary of the facts of the case? Your Justice, as the
Counsel, you are allowed to present your case as you see fit, but just as it does not exceed the allocated time to you.
If it pleases the court, I would like to contextualize the case a little. Justice, within the society that we live in, there's a dynamic that demonstrates the school's regulation, posing a threat on most critical people's rights just to neutralize unorthodox behavior, while there are other alternatives which can neutralize and favor the rights also. Your Justice, when coming to the constitutionality of Section 4 of the School Code of Conduct, we also refer to Section 14 of the Constitution, which deals with privacy. Section 14 stipulates that everyone has the right to privacy, which includes the right not to have A, their person or home searched, B, their property searched, C, their possession seized, or D, their privacy of communication infringed. Your Justice, we also submit that the manner in which Section 4 of the School Code of Conduct was applied by the school was unconstitutional. Your Justice, learners' bags were searched.
Counsel, sorry, you said so the manner in which the school's code of conduct is applied is unconstitutional.
Yes, Your Justice.
Are you then saying that the code of conduct itself is constitutional? It's just the manner in which it was applied. So you're saying the code is constitutional, but the manner is unconstitutional, or are you saying both are unconstitutional?
As the court pleases, can Your Justice please repeat your question?
So you said the manner in which the code of conduct was applied is unconstitutional. So
yes, Your Justice.
Are you saying that the code is constitutional or that the code is unconstitutional?
As the court pleases, they were both unconstitutional. Your Justice, the learner schools bags were searched. We also submit that this is a clear violation to subsection A, which stipulates that everyone has the right not to have their person or home searched, and subsection B, which stipulates that everyone has the right not to have their property searched. Your Justice, we also argue that the school unlawfully ordered a search of the entire school, which is prohibited by the highest law of the land, which is the Constitution. Your Justice, we then realized that it may be stated that the school wanted to ensure the school rules were followed. We argue that the search was not a correct manner to achieve these purpose. Your Justice, we would also like to refer to Section 4 of the School Code of Conduct, which stipulates that the usage of cell phones, whether on or off by learners at school premises, shall at all times be prohibited, and any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended. Your Justice, we would also like to submit to the court that this section is in clear violation to subsection C of the right to privacy, which clearly states that everyone has the right not to have their property seized. We then stipulate that the usage of cell phone will be confiscated is a clear violation to this right, which shows the House that Section 4 of the School Code of Conduct was unconstitutional. Your Justice, to further prove to this House that Section 4 of the School Code of Conduct is unconstitutional, we also refer to Chapter 2, Section 9 of the South African Schools Act, which deals with suspension and expulsion from public school. Subsection 1 stipulates that, subject to this Act and any applicable provincial law, the governing body of the school may, after the hearing, suspend a learner from attending school as a correctional measure for a period not longer than 1 week. Your Justice, we therefore submit to this honorable court that only one learner, which was FISO, went for a hearing, but the other 6 learners were suspended for the rest of the year without any form of formal hearing, thereby completely ignoring the South African Schools Act and applying Section 4 of the School Code of Conduct unlawfully. We also see such unlawful action when the principal decides to suspend the learners with immediate effect without consulting the SGB. This proves to this honorable court that Section 4 and its application is unjust and unconstitutional. As it pleases the court, I would like to start with the case of MEC for Education, KwaZulu-Natal versus Pillay and another, paragraph 98, where it was held that both discipline and education are legitimate goals. However, care must be taken not to the state school interest too broadly. Your Justice, we also submit that Section 4 of the School Code of Conduct states that schools' interest too broadly, as it prioritizes the school's interest too broadly because it prioritizes discipline while infringing upon people's rights. Since it advocates for confiscation, which is a violation of Section 14 of the Constitution. We will also state that in its application, pupils were suspended for the rest of the year, which does not clearly clarify the timeline and seems to support the school's interest while violating Section 9, subsection 1 of the Schools Act. Your Justice, we will also like to refer to the South African Schools Act number 84 of 1996, Chapter 2, Section 8, subsection 2. A code of conduct referred to in subsection 1 must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. Your Justice, we will also submit that the school was harsh in its application of Section 4 of the School Code of Conduct when they suspended the learners from school. We also argue that this application defeats the aims that should be achieved by a school's code of conduct, as previously stated. Your Justice, we would like to show this honorable court how Section 4 of the School Code of Conduct violated learners' right to education. Justice, we then submit that Section 4 of the School Code of Conduct violated learners' right to education because they are suspended from school. Justice, we first refer to Section 36 of the Constitution, which states that rights in the Bill of Rights may be limited only if limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Justice, we realize that the suspension is aimed to accomplish some purpose, but we argue that there are less restrictive means in order to achieve its purpose that are supported by Section 36 of the Constitution. We argue that
what would those means be, Counsel? What would those less restrictive means have been?
As the court pleases, detention, Your Justice. As the court pleases, we also like to refer to Section 28 of the Constitution, stipulates that best interests are of paramount importance in every matter concerning the child. We also submit that the school did not recognize the interest of the learners and were only focused on instilling discipline within learners and not realizing that receiving proper education is in their best interest. We also argue that the suspension stated in Section 4 and applied was a clear violation to the people's basic right to education in terms of Section 29 of the Constitution. Counsel for applicant requests this honorable court, 1, to declare that the High Court was incorrect in finding the constitutionality in Section 4 of the School Code of Conduct and finding that there was no clear violation to the right to education. As the court pleases, I would like to hand over to my co-counsel. Thank you. As it pleases the court, I am Matilisa Tladi and I'll be appearing on behalf of the applicant. Your Justice, I'll be focusing on issue 2, which is whether the SGB's decision is unconstitutional. I'll be proving to the House that the SGB's decision is unconstitutional, as it violates the learners' right to peaceful assembly in terms of Section 17 of the Constitution. In our attempts to prove that respondent violated the learners' right to peaceful assembly, we will also be referring to the South African Schools Act and the Mulukes Mulungwana and others. This is another 2019 Constitutional Court. Your Justice, we submit that the SGB was unconstitutional as it violates the learners' right to peaceful assembly, as learners were suspended for picketing against the injustice present in the school. Your Justice, Section 17 of the Constitution, which is assembly, demonstration, picket, and petition, stipulates that everyone has the right to peacefully and unarmed to assemble, to demonstrate, to picket, and to present petition. Justice, since the SGB's decision was based on the first protest that took place, even though it was spontaneous, we argue that when the pupils convened to picket, they were unarmed and they did not destroy any school property, which shows that they were responsible and were practicing their right. Your Justice, to further show the injustice in the SGB's decision, we refer to case Mulungwana and others versus Pillay and other 2019 SARC 429 Constitutional Court paragraph 43, where it was held, Section 17 guarantees to right assembly peacefully and unarmed. The content and the scope of this right must be interpreted generously, but its meaning is clear. Everyone has the right to assemble, picket, and present petitions. Justice.
Just to interject the council. So you are saying that the learners have a right to peaceful assembly and to picket and demonstrate. So was the protest peaceful? Because if I'm not mistaken, that evening there was a fire which broke out. So was the picket peaceful?
As it pleases the court, yes, can the justice please reverse the question?
So my question to you, counsel, is, I do agree that the students have a right to picket and demonstrate peacefully. But my question to you is, was the picket peacefully?
As it pleases the court, yes, the picket was peaceful because the pupils were unarmed and there was no evidence that they were the ones who started the fire.
Okay. So, your first counsel also said that the school's code of conduct does not infringe on the right to basic education. But now, the sanction which was imposed, it was a 1-year sanction. Don't you think perhaps that such a sanction is too harsh, and perhaps there are other restrictive means which could have been used instead?
As it pleases the court, yes, there was supposed to be other impression that would be used, like detention.
Okay, so you do concede that the sanction was too harsh?
Yes, as it pleases the court, yes, it was.
Okay, you can continue, counsel, with your argument.
Justice, we argue that the requirement for practicing this right is that it must be done peacefully and all must be unarmed. The only requirements are that anyone exercising this right must do so peacefully and unarmed. Another important sector of this paragraph stipulates that whatever their station in life, everyone is entitled to exercise the right in Section 17 to express their frustration, aspirations, or demands. Anything will prevent unarmed persons from assembling peacefully will thus limit the right in Section 17. Your Justice, we need to recognize that pupils were unarmed and they showed no signs of hostility towards the teachers. Even when the police were called, they were not detained. We need to recognize no matter the status of one in life, they are afforded this right and have the support of the law to practice it. We argue that any limitation imposed on this right in this situation were unjust. Your Justice, we realize that it may be argued that learners were required to provide notice before convening to picket, as it is stated by the Regulation Act. For this, we refer to case Mulungwana and others versus and another 2019 one SAC.
Council, just to understand you correctly there, you are saying that well, according to me, and as far as I'm concerned, when people intend to demonstrate, they must give notice, but your clients did not give notice. So what do you have to say about that?
As please the court, they did not provide notice because their gathering was spontaneous. I
Okay,
hope
thank you, Council. Continue.
Paragraph 2, where it was held that Section 12(1)(a) constitutes an unjustifiable limitation of the right in Section 17. We therefore argue that this limitation is unjust, as it deters a convener from picketing, which is necessary when a person with no economic or political power to fight injustice. We would also like to cite paragraph 16, where it was held that if a gathering proceeds without a formal notice, then Section 12(1)(a) provides that it is a criminal offense to convene a gathering without giving the
Council, you said that well, I told you in the beginning of the session that you have 20 minutes to speak, and you said that you will be reserving some time for rebuttals. Is that correct?
Yes, it is correct.
And now both you and your counsel combined, you have spoken for close to 18 minutes. And that means that you only have 2 minutes left, including your rebuttals. So yes, I don't know. It's either you wrap up your case as you see fit. Yes.
I would like to wrap up the case and leave the rebuttals.
Please note that you do not have any further time now. Just wrap up your case and there won't be any further time for rebuttals since your time is up.
Failure to give notice of under Section 12(1)(a), it is open to a convener to invoke a defense that the gathering consent took place spontaneously. Your Justice, we argue that convener of this particular spontaneous gathering did invoke that it was spontaneous, that law officers did not detain or have them prosecuted, which shows that the gathering was legal. Which makes you wonder why the
30 seconds left. 30 seconds left.
Why the school took actions against them. We argue that the learners were justified to express their frustrations about the injustice in the school because teachers used corporal punishment to discipline pupils, which is prohibited by law, and pupils were being suspended without hearing. No matter the circumstances of the school, these actions are injustice against pupils. Thank you.
Okay, thank you very much, counsel for the applicant. Counsel for respondent. Counsel for applicant, please just mute yourself in the process. Counsel for respondent, you may begin. Your time is counting, please.
Chief Justice, your justices. My name is Masero Mpela, and to my left is my co-counsel Moloko, and we will be appearing on behalf of the respondent. I will speak for 10 minutes
just to stop you there for a brief moment, counsel. Please just type your name. Please just type the name of the first speaker and the name of the second speaker on the chat box, please.
On it.
Yes.
Yeah, type. My co-counsel will start typing now.
Okay, you can see that. Please continue.
Chief Justice, your justices. My name is Mpila Masero, and to my left is my co-counsel Moloko Molele, and we will be appearing on the respondent. I will speak for 10 minutes, and my co-counsel will speak for also 10 minutes. I will be addressing the issue of the school's code of conduct, if it's unconstitutional or not, and my co-counsel will be further addressing about section 17 of the Constitution. My lords, the matter in question today is the constitutionality of section 4 of the school's code of conduct and whether the learner's rights to privacy and basic education were violated, respectively, as composed in the Constitution. We further question the constitutionality of the SGB's decision, whether it violates the learner's rights to peaceful assembly or not, in terms of section 17 of the Constitution, respectively. Honorable judges, discipline is indispensable for effective teaching and learning in a school. A code of conduct promotes proper and good behavior and sets standards for positive discipline. During the drafting and final adoption of the school's code of conduct, all members were consulted, and for this very reason, we believe that our school's code of conduct is constitutional, and as such, its implementation and enforcement cannot lay ground to its unconstitutionality. Well, after the learner overstepped the disciplinary rules, the principal saw it fit to search every bag of other learners to ensure that no one was in possession of their cell phones. This cannot be seen as invasion of privacy, but as a way rather to avoid setting a precedent. Counsel, for the respondent acknowledges that the rights and interests of the learners in the sub-event position are at stake, but my lords, a possibility exists that the school's day-to-day running may be influenced by the events in question. My lords, the right to privacy affords a greater intensity of protection to personal activities within the centrum of a whole. According to a case between Mystery versus Interim National Medical and Dental Council of South Africa, the Concord stressed out that the more public an undertaking is, the more anti-weighed would any corresponding claim to privacy would be. This means that whenever you are in public, your right to privacy cannot be that protected as you are in your own personal space, for example, in your room or at home. The moment you start engaging in public activities, like some extramural activities, the intensity of the right immediately diminishes. We would like to bring light to the court that the right to privacy will be at its greater use when, for example, like I have said, in your own personal space, at home, or at a gathering with less than 15 people.
Counsel, I would like to interject here. Are you saying that people engaging in a public forum have no right to privacy, or to what extent is their right to privacy diminished?
What I am saying is, when you are at home in your own private place, your right to privacy is highly protected than when you are in a public space, like at the mall or at a gathering with full people.
Okay,
But
so counsel, are you implying that being at the school, you are in a public space, therefore you do not have the right to privacy, or the right to privacy is diminished somehow.
What I'm saying is, when you are at school, your right to privacy it is still there, but it is not as strongly protected as you are in your own personal space.
Okay, why would that be? What's the reason for that?
In this case, if the school wishes to search the learners' bags periodically to avoid, this would be to avoid learners being in possession of harmful substances such as drugs and other things in the school's premises. So they do this in order to keep the discipline in the school.
Okay, thank you, Council. You can continue.
Thank you. Your Worship, I would like to bring to light the fact that bringing a cell phone to school is a privilege given by the school's management, and as such can be taken away at any moment to bring about change and drive school learners to a positive discipline. I believe the court will agree with me when I say that ever since the principal arrived at the school, there has been greater improvements. The introduction of the school's code of conduct, section 4 to be precise, is in no way unconstitutional, as it does not violate the learner's right, any of the learner's rights. My lords, a line must be drawn to distinctly differentiate between a constitutional right and a privilege.
Council, you say that ever since the new principal came into the school, there have been great improvements. What improvements were those? Because according to me, and I remain to be corrected by you, of course, according to me, the pass rate had already increased long before the school's code of conduct was enacted, or perhaps I'm mistaken.
In me and my co-counsel's understanding, we believe that there was a greater improvement in the school's pass rate after Ms. Koza was introduced in the school and has introduced tough love as their motto, and the school's code of conduct was introduced.
Okay, thank you.
My lords, in January 2011, the new act was passed, which provided clearly defined powers to conduct search and seizure operations at school. In our case, we believe that the principal to be right to conduct the search, as she had a reasonable suspicion that a breach of code of conduct was being committed, and she also had a reasonable cause to believe that the search was necessary to maintain school discipline or enforce a policy. If the court permits, the council would also further like to add that the Learners Act brought about an imbalance in the school's environment, and as such, the rights of the majority must be protected. This implies that limiting the rights of the suspended learners would not be a violation, but rather a way to restore legal balance to the school environment. I would also like to bring light to the fact that some other children are not able to afford smartphones like the ones that brought their cell phones to school, thus making them feel under pressure and pressurizing their parents to buy them cell phones that they can't afford. So the school's code of conduct, we submit that the school's code of conduct is constitutional, and it is thus reasonable. If there are no...
Council, were there not other ways? I mean, the applicant suggests that the students could have been given detention, or I might suggest that they could give them a shorter suspension. Was there not something else the school could have done rather than suspend them for the whole year?
Can you please repeat the question? I didn't hear you.
Was there not something else your client could have done to these students rather than suspend them for the whole year? Could they have given them detention or suspended them for a shorter period?
Okay. We believe that there are many ways to discipline a learner, but Based on the school's background and the rebelliousness of the learners, we believed that suspending them for 2 months would make them realize how serious the misconduct that they committed is.
Council, you have reached your time limit.
I thank you.
Okay, then second speaker for the respondent.
If it may please the Lord, my name is Molele Moloko, as my co-counsel has spoken. Honorable Court, it all now boils down to learners conducted an illegal search, an illegal protest, and should be seen guilty of. The applicant indicated Section 17 of the Constitution, which states that everyone has the right to peacefully unarmed to demonstrate, to protest, to picket, and to present their petitions. Yes, the learners may evoke their right to protest, but they should not turn a blind eye to the stipulations that the protest must be conducted peacefully. Your Justices, if a gathering proceeds without a formal notice, then Section 12(1)(a) of the Regulation of Gatherings Act of 1993, Act 205, provides that it is a criminal offense as prescribed in the Act. It is a criminal offense to convince a gathering without giving the requisite notice as prescribed in the Act. We believe that Section 12(1)(a) constitutes a limitation to the right to freedom assembly in terms of Section 17 of the Constitution. We say this because of the chilling and deterring effect criminalization that could have negatively impacted the school's quality of learning process. If the learners should have assembled and exercised their right, therefore they should have made sure that it was peaceful, as if they have exercised their right to protest in no intention of acting peacefully, they have lost their constitutional protection, as the limitation of their right to assemble is justified. As such, the SGB's decision must be viewed as appropriate. Your Justices, let's bear in mind that on the day of the protest, of one of the protests, one of the buildings of the school was set on fire. And arrests were made. Not everything is about protesting, and I believe that if the learners really wanted if they really wanted their message to be communicated properly, they should have looked or adopted a more peaceful or superior way to communicate their matters. And if they really felt like their rights were violated, why didn't they send their parents to school to communicate with the principal about the issue? Furthermore, my lord, if there is that right of protesting and they felt like it was violated, why didn't they write a petition instead to also communicate their issues? In summation, we would like the court to rule in our honor by so saying the learners should be found guilty of arson, vandalism, and breaking the school's code of conduct, as they also set the school's building on fire. We believe that they should be dealt with accordingly, as they committed a crime, which is arson in South Africa.
Council, what evidence do we have that it was these students who burned the building? The police have yet been able to find evidence of that.
There was no evidence provided, but the arrests were made by officials of justice. And I believe that they wouldn't make a mistake by identifying the learners as the suspects and making those arrests.
Okay. Council, you do concede that without a criminal trial taking place and then being found guilty of arson, the Constitutional Court cannot possibly find the learners guilty of arson.
The Supreme Court declared that, the Supreme Court declared that those learners were not acting constitutional based on the general application of law. Thus, we believe that they should also be dealt with accordingly, as I've said. And also bear in mind that the schools in South Africa are regulated in Accordance Schools Act, Section 8.2. Therefore, the learners were acting unconstitutional based on the regulation of Gatherings Act number 205 of 1993, as said before. Thus, we submit that the respondents are not guilty of any charges pressed against them, and they did not violate any of the applicant's rights as per declaration. Counsel for the respondent respectfully requests that may this honorable court to declare that the Supreme Court was correct in finding that there was no violation of the right to basic education and privacy. And to also rule out that the SGB's decision was fair and constitutional and can be subject to Section 36 of the Constitution, since the Learners' Acts were illegal based on the law of general application. And would also like to bring to light that Sir William Blackstone adopted or introduced a new law in 1769. And Sir William Blackstone is the jurist judge of the 18th century. He introduced the in loco parentis law, which states that the custody of control of a parent, if they have entrusted the custody and control of their child to an education or an intramural, they should have not been found guilty of anything that, or found wrong of anything that they were doing, as their parents entrusted the custody of the children, and they were acting in place of their parents. Respectfully submitted, counsel for the respondent, I would like to rest my case if there is no further questions.
Okay, thank you very much, counsel for the respondent. According to the timekeeper, according to Judge Olivier, she says that she has timed the applicant for 8 minutes and that they still have 2 minutes for rebuttals. So applicant, if you want to rebut, you have 2 minutes starting from now.
The case, as the court pleases, the respondents say that discipline is important. To respond to this, we also refer to the case MEC for Education, KwaZulu-Natal and others, versus Pillay, paragraph 98, where it was held that both discipline and education are legitimate goals. However, care must be taken not to state the school's interest too broadly. And we also say that discipline is not that important because education should be protected. The response also say that the right to privacy was not violated because it's not supposed to be protected, and we say that the school is well within its right to conduct a search. Your Justice, we also submit that the only limitation on the right to privacy in the school as expressed in South African Schools Act, but this act clearly states that a search can be conducted if a suspension arises that learners are carrying illegal objects or dangerous objects. We argue that a cell phone does not in any way can be seen as a dangerous or illegal object. Your Justice, respondents also say that there was a fire. Justice, the fire only occurred a few hours later after the protest, and there is no evidence that they started the fire. As the court pleases, thank you.
Okay, thank you very much, counsel for the applicant. Justice Olivier, does the respondents still have some time left.
Yes, the respondent has about 20 seconds left.
Okay, so respondent, you have 20 seconds left, starting from now.
In conclusion, we would like to state that we believe that our code of conduct is constitutional, and no matter how discipline should be in the school, we know that the SGB and the principal are responsible for keeping it, and the SGB is responsible for keeping the code of conduct constitutional. Let us remind the court that
Respondent, your time is finished.
Okay, thank you very much from both team applicant and team respondent. I don't know if ever Justice Olivier and Justice Thomas have any feedback to give to the teams now, or you'd prefer to actually write your feedback in the score sheet?
Maybe not necessarily feedback, but just an encouragement to the teams to pursue this and pursue a sort of a legal career. I recall starting these things at school. I did moot competitions, and now I'm practicing, and I'm going to do my pupillage next year to become an advocate. So just an encouragement to them to pursue this, to pursue a legal career.
Okay, thank you very much, Justice Thomas. Justice Olivier?
Yes, I would just like to congratulate the teams on their presentations. And I would like to motivate them to maybe take a deep breath before they answer our questions. And I realize that you're very nervous, but just remember that this is more like a conversation than it is a test of whether or not you will stick to your point. So if the judge asks you a question and the judge is likely trying to help you to formulate your points in a clear way. So perhaps just look out for those questions that offer you guidance in articulating your argument.
Okay, thank you very much, Justice Olivier. I'll also just reiterate on that yes, although this is a competition, you also have to remain calm and not panic. Yes, just don't be nervous and don't let your nerves get the better of you. And yes, I believe that you guys have a bright future. And thank you very much for participating in the National Schools Moot. Yes, just make sure that you pursue a legal career. Yes, just work on your matric exams and get university admission. Yes, thank you very much. So I guess that this session is dissolved then. Both team applicant and team respondent, please just remove yourself from the session so that the next session can commence. Thank you.
Sorry, I have a question.
Yes. Justice Pillay, I see that there are also other participants. So yes, I just want to know who the other participants are. Who is team 214? Okay, so team 14, well, team 214, which is the applicant, they've logged in twice.
I think they are team support members.
Okay, so who is Zugisa Nolu Mkakanya?
I think that's from the commission.
Okay, thank you. Well, I have no further concerns.
Okay, respondents, we are waiting for you. When you are ready, we will begin the proceedings.
Your Justice, are you sure you can see us both and you can see us both in colors?
Yes, we can. I'm not sure why it's not showing that way on your side, but we can see, at least I can. I don't know if my fellow judges can see you, but I can see both of you in color.
I can see
your beautiful faces and hear you clearly.
Thank you.
Okay, respondents, is everything fine on your side?
Good day, Your Justices. I am Andy Nyaga, together with my co-counsel, Mbanga Mlari, and we appear on behalf of the respondent.
Okay, thank you for that, respondents. If you guys could please type your names in the chat box so that we have the spelling of it.
Want to check your names?
In the chat.
Speaker.
Okay, thank you for that. And first speaker, how long will you be speaking for?
If it pleases the Court of Justices, I'll be addressing the issue for 10 minutes and my co-counsel will be addressing the issue for 10 minutes as well.
Okay, thank you. I just want to make the respondents aware that after the applicants do their rebuttal, you have the opportunity to do sir rebuttal, which is to reply to whatever the applicant is saying in their rebuttal. But your sir rebuttal may not go on for longer than 2 minutes. So if you would like to reserve time for sir rebuttal, please let me know.
Your Justice, can I rebut the applicants after my submissions and arguments? If
So
I still have
the applicants will speak, you will speak, the applicants will do rebuttal, and then you get 2 minutes afterwards to respond to the applicant's rebuttal. Okay. All right, without any further delay then, I think that we can begin. I ask everybody to please mute themselves if you're not speaking, and I call the first speaker of the applicant to please present before the court.
As it pleases the court, I am Bertha Mutsagani and I'm here with my co-counsel, Aluto Luwata, and together we represent the 6 learners of Mjondolo Combined School, the applicants. I will be arguing that Section 4 of the Schools Code of Conduct is unconstitutional and violates the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. And my co-counsel will argue that the SGB's decision is unconstitutional and violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution. The counsel for the applicants making use of the Constitution, South African Schools Act, and articles will prove that Section 4 of the Schools Code of Conduct is unconstitutional and does violate the learner's right to privacy and basic education in terms of Section 14 and 29 of the Constitution. The counsel for the applicants finds Section 4 of the Schools Code of Conduct is, however, unconstitutional and irrational. Quoting directly from the Schools Code of Conduct, it stated that any learner found in possession of a cell phone will have that cell phone confiscated. Now, your justices, that statement is very clear. However, the statement preceding this one stated that and may be suspended. Now, maybe implies that there's a possibility that a learner might be exempted from suspension although found in possession of a cell phone. Paragraph 170 of the KwaZulu-Natal versus Pillay of 2008, ordered by the Constitutional Court, states that the Code of Conduct did not contain any express provision for exemption, either to regulate in what circumstance they would be granted or to establish a procedure whereby an exemption could be obtained. Now, this fact is true, as this Code of Conduct lacked clarity as to under what conditions will a learner be exempted from suspension, although found in possession of a cell phone, and as to under what conditions will a learner not be exempted from suspension, although found in possession of a cell phone. The Code of Conduct is implemented with immediate effect. Now, we allege the irrationality of this Code of Conduct as it does not comply with Section 8 of Section 1 of the Constitution, stating that a governing body may adopt a Code of Conduct after consultation with the learners, the teachers, and the parents of the school. Section 5.1b of the Schools Act states that learners must be involved in the formulation of school rules. Now, your justices, if this statement was actually true, we would not be here to contest its constitutionality or its fairness. Umjondolo Combined School lacked discipline, hence.
Doesn't the facts show us that parents, children, and even the educators, some of them, although they agree that the discipline is harsh, that it's brought benefits such as increase in the matric pass rate, and most of them welcome the change. So what difference would it make?
Your justices, despite the benefits, it does not defy the fact that it's still unconstitutional because there are benefits to it that does not make it lawful. I hope that answers your question, your justices. Permission to proceed. Umjondolo Combined School lacked discipline, hence the Code of Conduct. With reference to the consideration of adopting a school code of conduct, which was recognized by the South African Schools Act of 1996, it states that a school code of conduct must not be punitive or punishment orientated. We submit, your justices, that Umjondolo Combined School was merely focused on punishments, as now teachers were making use of corporal punishment, learners were being punished for the smallest of transgressions, and all 6 of the learners were suspended. Paragraph 17 of the Antony versus the governing body of 2002, ordered by the Constitutional Court, states that the question should be asked in this regard, whether or not prohibition is aimed at positive discipline and whether or not non-compliance therewith justifies punishment or some other form of sanction. Now, your justices, cell phone carriage does not justify suspension for the rest of the year. In fact, it only dismisses the learner's rights to education. Sfiso's phone falls out of his pocket and is confiscated. He is granted a disciplinary hearing to which he does not succeed as he is suspended for the rest of the year. Now, the 6 learners are found guilty of the exact same offense as Sfiso, however, they are not granted a disciplinary hearing. Now, your justices, this is absolutely unjust, as everyone is equal before the law and has the rights to equal protection and benefits of this law in terms of Section 9 of the Constitution. Section 9 of Section 1E of the Schools Act states that a learner may be suspended for a period not longer than 14 days. But here we find that Sfiso and the applicants were suspended for the rest of the year. This violates the rights to basic education in terms of Section 29 of Section 1 of the Constitution. We submit to this honorable court, your justices, that a child's interest is of paramount importance in every matter concerning the child, in terms of section 28, subsection 2 of the Constitution. This is not the case with the respondent, as teachers were now making use of corporal punishment, which was prohibited in terms of section 10 of the Schools Act. We substantiate further by saying that some of the learners who were suspended were in grade 11. And as we are all fully aware of the importance of the grade 11 results for provisionary acceptance in varsity. Now, due to absentia, failure is...
I appreciate that, and I do agree that it's important that the children remain in school. But given that they know how important it is, they were aware that the rules say that they shouldn't have a phone with them. But despite this, they still had phones on them. If they had a problem with the code of conduct, isn't there some other way they could have gone about it instead of just defying the rules immediately?
Your Justice, the only other way was through a disciplinary hearing for them to at least petition their grievances as to why they brought their phones to school, because the resistance should be evident that there's a reasoning behind it, because the rest of the school does not bring their phones, but only the 6 learners. I hope that answers your question, your Justices. Permission to proceed.
Okay, just before you proceed, Counsel, since you say that the suspension for a period of 1 year is too harsh, so what other less restrictive means do you suggest?
Thank you so much for that question, your Justices. If the school, however, had involved the learners in the formulation of the code of conduct, we allege that another way out would have been that they allowed the phones to be brought to school. However, during first registration, the phones are handed in to management, and therefore during the duration of school times, the phones are not with the learners. Then during last registration, the phones are released back into the care of the students. That could have been another alternative.
Okay, thank you very much. You can proceed.
Thank you. The respondent dismisses the learners during school times. Now, your Justices, this is absolutely humiliating to the learners. The respondent was, however, harsh, as they should have dismissed the learners after school and allowed them to proceed with the day's lessons. The mere fact that the respondent was quick, if not hurried to dismiss the learners during school hours, shows that this code of conduct has no regard at all for the learners' rights to education or human dignity in terms of section 10 of the Constitution, which states that everyone has inherent dignity and has the right to have that dignity protected and respected. Section 8A subsection 2 of the Schools Act states that a principal or his or her delegates may search a group of learners for dangerous objects or illegal drugs. Ms. Koza orders a bag search and 6 cell phones are found. Now, your Justices, a cell phone is nowhere illegal or dangerous. And nowhere in the Code of Conduct or in the Schools Act does it warrant a search for a cell phone. Due to that reasoning, the respondent has violated the learner's rights to privacy in terms of section 14 of the Constitution. I have come to the end of my argument. If there are no further questions, I would now pass on to my co-counsel. As it pleases the court, I will take my leave.
Counsel for the applicant, whenever you are ready, you may begin.
As it pleases the court, I am Aluto Luat, and I will be appearing on behalf of the applicant. Your Justices, with 9 minutes of analyzing issue 2 being the submission that the SDB's decision was indeed unconstitutional and violated the learner's right to peaceful assembly in terms of section 17 of the Constitution. Now, your Justices, the counsel for the applicant contends the main points that will challenge the SGB's decision as unconstitutional. We submit that in accordance to section 39, subsection 1 of the Constitution, it states that when interpreting the Bill of Rights, a court tribunal, or forum must consider international law. Reason being that South Africa ratified its treaty and has agreed to be bound by its provisions. Therefore, we state that in Article 21 of the United Nations International Covenant on Civil and Political Rights, that the right to assemble shall be recognized, and that no restrictions may be placed on the exercise of this right. We also submit, your justices, that this right may be exercised by all, non-discriminatory of age. As Article 15 of the United Nations Convention on the Rights of the Child continues to state that all parties recognize the child's rights to assemble peacefully and to freedom of association. Now, your justices, in Article 8 of the African Charter on the rights and the welfare of the child, it also says that everyone has the right to assemble freely with others. The counsel for the applicant, in line with the South African Schools Act, the Constitution, relevant articles and paragraphs, will continue to elaborate that indeed the SGB's decision was unconstitutional. In accordance to paragraph 61 of the Satao and others versus Garvis and others that was ordered by the Constitutional Court in year 2013, it states that the right to freedom of assembly is central to our constitutional democracy. It exists primarily to give a voice to the powerless, which in this case, your justices, is the applicant. Yes,
just to interject there, Council, I do concede that the right to peaceful assembly is central to our democracy, and it is an essential right which gives people a voice to demonstrate and picket. So now my question to you is, was the protest peaceful?
Your justices, firstly, we would like to submit that the police had investigated the scene and no culprits were found. Second, we state that we refer to Section 11, subsection 2 of the Gatherings Act number 205 that states that, your justice, it shall be a defense to claim against a person or organization contemplated of such a person or organization proves that he or it did not permit or connive of the act or omission which caused the damage in question, and that this act did not fall within the scope of the objectives of the gathering and was not necessarily foreseeable. We submit this, your justices, as we state that the applicants were only just discussing the unfairness of the situation, and it was never the intention of the applicants to any of the damages that were caused.
Okay, Council. Okay, so you are basically saying that because the police investigated the fire brigade, which broke out later in that evening, and so we cannot link any of that to the actions of your client since no culprits were found. Okay.
Yes, you just.
So what about the fact that for you to picket and demonstrate peacefully, you ought to have given notice beforehand? And if I'm not mistaken, your client did not give any notice. So what do you have to say in relation to that?
Thank you very much for that question, your justice. I refer to paragraph 16 of the Mlungwane and others versus S and others that was ordered by the Constitutional Court in year 2019 that states that it is criminally liable for the convener to failure to give notice, and however it is open for this convener to invoke a defense that the gathering concerned took place spontaneously. And we submit to your justice that this gathering was definitely an example of one that took place spontaneously, as the 6 applicants did not plan for this protest and did not approach any of the learners that started joining. If that answers your question, your justice.
Okay, thank you very much. You can continue.
Thank you, your justice. I would quickly refer to paragraph 98 of Paragraph 98 of the MEC for Education, KwaZulu-Natal and others versus Pillay, that was ordered by the Constitutional Court in 2008, that states that both discipline and education are legitimate goals. However, your justices, care must be taken not to state the school's interest too broadly. Your justices, we would like to contextualize the case to begin with. The counsel for the applicant states that Sfiso Cele, as my co-counsel had mentioned, was the only student that was given a chance to go under a disciplinary hearing, which then violates the rest of the 6 learners of the Audi principle, which means to consider the other side. Your justices, not only did violate the Audi principle, but it continued to compromise Section 9 of the South African Schools Act, that a governing body can only enforce such a suspension after reasonable representation has been made to it, your justices. It is to these horrifying reasons that these learners gathered together to discuss the unfairness of the situation. Your justices, we would like to highlight that the applicants wasn't only deprived of their right to a protest, but rather first they were deprived. Yes, your justice.
I appreciate that, but while on one hand, we worry about these alleged offenders and the fact that they've been deprived of their education because of the suspension, etc. What about the fact that during the protest, they blocked the school entrance and they didn't allow a lot of kids who wanted to just go about a normal school day? Those kids were deprived of their education for that day. Shouldn't we hold the perpetrators accountable?
Yes, your justice, but you need to consider the fact that according to the states that were given, it is stated that there was great resistance against the measures that were taken in the school, even before the amendment of the school's code of conduct. However, the respondent, being the school, never took any consideration of this great resistance, meaning that the applicants have always been in a position where they were never able to share their concerns, your justices. And this honestly was the only measure that they could have taken, given that they were never ever listened to in the first, your justices, if that answers your question.
So what you're saying is that the right to fair hearing of the applicants was infringed.
Yes, your justice, that is what you're submitting.
You may continue.
Your justices, not only were they deprived of their right to a protest, but they were also, your justices, my time is running. I would like to conclude. We would like to bring it to the court's attention that Sfiso Cele did not join the protest. This reason is that Sfiso Cele was already given the chance to undergo a disciplinary hearing. So, your justices, we state that if the applicant too was given the right to undergo a disciplinary hearing, they would have not staged a protest. We state that we refer to paragraph 52 of the Satawa and others versus the Gavas and others that was ordered by the Constitutional Court in year 2013, that everyone who is unarmed has the right to assemble, to picket, to petition and demonstrate in any lawful purpose. The counsel for the applicant states that the applicant met its requirements, your justices, and it meets the law's requirements and remained unarmed, your justice. The applicant also, thank you, your justice.
Thank you for your submissions, applicants. I'd then like to call upon the first speaker of the respondent to make their pleadings before this court.
To remind the court, your justices, as I have mentioned before, I am Atanile Myaga and I appear on behalf of the respondent. Today, your justices, I'll be taking 10 minutes of this court's time and I'll be addressing the second issue, which is whether I'll be addressing the first issue, which is whether or not the SGP's decision, Section 4 of the School's Code of Conduct is not unconstitutional as it does not violate the learner's rights to privacy and basic education in terms of Section 14 and 29 of the Constitution. And my co-counsel Lubanga Mlamli will be unpacking the second issue, which is whether or not the SGP's decision is not unconstitutional as it does not violate the learner's rights to peaceful assembly in terms of Section 17 of the Constitution. If it pleases the court, your justices, I would like to talk about the privacy, which was limited in this instance. Your Justices, privacy, we know that privacy is a fundamental right, but there are activities that restrict the right to privacy, such as surveillance that can only be justified when they are prescribed by the law, necessary to achieve a legitimate aim and proportionate to the aim that is being pursued. Your Justices, with the use of Section 36, which is the limitation clause, we have limited the learner's rights to privacy because there was a reasonable and justifiable cause to search these learners for the cell phones, because there was a valid suspicion when the cell phone dropped out of Sfiso Cele's pocket. This then raised an awareness that learners actually do bring cell phones to school, and we had to search them so that we can see that Section 4 of the School's Code of Conduct is being followed by the learners, and they are not opposing this section of the School's Code of Conduct. Your Justices, the aim of this search was to find cell phones which are disruptive and dangerous to the school. Coming from the history and background that the learners who were bringing cell phones to school were not bringing the cell phones for justifiable and good reasons. They were bringing them to be on social media. This then was detrimental to them as they were practicing their rights to privacy unlawfully.
Are you by any chance bringing your own facts to this case? Because I remember reading the facts and there was no mention of social media in the facts. How sure are you that the students were using their phones for social media and not for research?
Your Justices, according to the first page of the facts, it is stated that before Mrs. Koza was appointed as the principal of the school, learners used to carry cell phones and were distracted by cell phones by being on social media, so they never took the teaching time effectively. If that answers your question, Your Justices.
Oh yes, thank you. Please proceed.
Your Justices, as I was saying, that coming from a history of the school, where learners brought cell phones for unreasonable causes, then this means that we cannot trust them as they use cell phones for wrong purposes, such as social media. In this schools, Your Justices, cell phones are the standard of education.
Sorry to disturb you, but while I understand that some children do bring phones just to have fun or to distract themselves, the applicants have told us that you've not made any room for exemption. So in the case that a child needs a phone for emergency purposes or for whatever reason, does that not make your code of conduct unfair that you have no exemption?
Your Justice, to answer your question, in the Section 4 of the School's Code of Conduct, it doesn't state that the phones should be brought to school if it's for a justifiable reason. It says that the use of cell phones, whether on or off, shall at all times be prohibited. So this means that any phone at the school is not accepted, whether it's for a good reason or not, Your Justice, if that answers your question. We cannot control the use of cell phones at school, as there are less teachers than the learners, Your Justices. If that answers your question, I'd like to give an example with our justification for the restriction of the learner's rights to privacy. Your Justices, for example, when you go to a retail store, they search you when you're about to depart or leave the store. So Your Justices, we submit that this is justifiable and reasonable, as they're doing that with people, as there have been people who were not acting according to that law, which is not to steal in the shop. So Your Justices, we submit that in this case of Mjololo Combined School, we search for learners because we saw that learners actually do bring cell phones to school. So we wanted to confirm, to make sure that Section 4 of the School's Code of Conduct is being followed by the learners, Your Justices. If it pleases the Court of Justices, I'd like to move on with my argument. The case that supports the limitation of privacy of the learners, which is the application of general law on the United Nations of the Universal Declaration of Human Rights, Article number 29, it is stated that in the exercise of these rights and freedoms, everyone shall be subject only to such limitations as one determined by the law solely for the purpose due to the recognition and respect for the rights and freedoms of others. Your Justices, with that being said, the learners infringe the rights of other learners to an environment, which is Section 4, subsection B of the Constitution, which states that everyone has the right to have their environment protected for the benefit of present and future generations. With that being said, Your Justices, to link this to this case, we are trying to say that the learners were not thinking carefully about the future the future generation of the school when they're bringing cell phones to school, as they're going to be disruptive to them and will shift their focus from academics to social media. Your Justices, if it pleases the court, we would like, in terms of education, we would like to submit.
Before you move on, you've mentioned that a limitation must be proportionate earlier. So even if these children are limiting other people's rights, isn't there a more proportionate means that you could have taken instead of saying that no phones may be on the premises whatsoever? Could you not have done what the applicants have suggested, for example, which is to hand in the phones to some authority figure and then be given the phones back at the end of the day, for example? Is there no less restrictive means?
Your Justice, we believe that the fact that we suspended the learners, this was a justifiable and reasonable cause, as we restricted the learners' rights to education. We would have expelled them, Your Justices, but then we decided to hold this problem in a fair manner, which is the suspension of these learners, Your Justices, if that answers your question. With that,
Counsel, just to add on top of what Justice Pillay has said. So Section 4 states that if ever it is contravened, then that learner who contravened Section 4 will be suspended for a period of up to 1 year. And don't you think that such a harsh punishment is actually an infringement to the right to basic education, because the learner will now be suspended for a period of up to 1 year and they won't be at school for a period of up to 1 year? So don't you think that perhaps such constitutes an infringement to the right to basic education?
Your Justice, I would like to disagree with you, because in terms of Section 4 of the School's Code of Conduct, it doesn't state that the school will suspend the learners for a whole year. It is stated that according to the Constitution, which is Section 9, subsection 1A of the Constitution, which states that the school should suspend the learners for a period not longer than a week, Your Justice. In the fact, it is not stated that how long the rest of the year was. Your Justices, we believe that if maybe in this instance, the learners were suspended 2 days before the school syllabus of the year ended, Your Justices, if that answers your question. I'd like to move on to the limitation of education, Your Justices. According to the NI Government Services of the UK, it is stated that a child can be suspended from the school when, one, they have seriously broken school rules, and in this case, these learners purposefully broke the school rule of not bringing cell phones to school, as that rule is instilled to keep order and respect in the school. Number two, allowing them to study in school would seriously harm their education of welfare, the education or welfare of other learners. And in this case, Your Justices, the applicants were infringing the learners' rights to education, and they were not limiting it because they are not, they were not limiting it because they are not authorized to limit any of the rights of the learners, Your Justices. And according to Section 36 of the Constitution, there was no law of general application when they decided to limit the learner, to violate the learners' rights to education. With that being said, Your Justices, we would like to submit that a learning environment is not for the benefit of one learner, but for the benefit of all learners in that particular learning environment. We submit South African Schools Act number 84 of 1996, section 8, subsection 2, which states that a code of conduct must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. Your Justices, our client produced all of the above, and now it is up to the applicant to maintain the quality of the learning process, which we see it failed in. And the applicants in this case, Your Justices, were infringing the learners' rights to basic education when they decided to bring cell phones to school, Your Justices. If it pleases the court, Your Justices, I'd like to hand over to my co-counsel, Lubanga Mlami.
Thank you for that. First speaker of the respondent. The second speaker of the respondent may approach the bench when they are ready.
As it pleases the Court, Your Justices, as my co-counsel has stated, I am Lubanga Mlamli, and today I'll be taking the second issue in today's matter, which is whether or not the SGB's decision is not unconstitutional and does not violate the learner's rights in terms of Section 17 of the Constitution of South Africa. And with that being said, Your Justices, we would like to move on to peaceful protest that the side applicant in this case alleges that they did. So, Your Justices, side applicant in today's case said we did not give learners the pedestal for them to voice out their concerns to what was happening in the school. We disagree with them fully in this case, Your Justices. We submit that indeed we did give the learners the pedestal for them to voice out any mistakes that have been done during the protest, as in the facts, Ms. Khoza sent a text to the parents of the learners, and which we see in this case, the learners actually contravened that in doing so, Your Justices. So in moving, Your Justices, we submit Section 36, subsection 1 of the Constitution, and states that which, due to the nature of the right and the importance of the limitation of due to the importance of the purpose of the limitation, we submit that the right to peaceful assembly must be subject to limitation in today's case, since it is solely dealing with children who are often associated with destructive actions in today's case, in which we see side applicant clearly showed us their true colors in actually protesting towards the school. So, Your Justices, we submit that by limiting this right, it will not be detrimental to the learners, but rather make them value education and actually value that other people's rights do matter other than theirs, and it is the majority's rights that we should consider in today's case rather than theirs in this context. And Your Justices, we further submit the Satao versus Garber's case, paragraph 52, which states that nothing thus far detracts from the requirement that the right in Section 17 must be exercised peacefully. And it is important to emphasize that it is the holder of the right who must assemble and demonstrate peacefully. It is only when they have no intention of acting peacefully that they lose their constitutional protection over this right, as the European Court of Human Rights had noted in today's case. So, Your Justices, we see, and as the court has identified, and side applicant, I guess in this case, has identified, that it is very important to note that it is the most important part of protesting is actually being peaceful. And we submit to this court that it is side applicant that the people who should maintain peace during this case. And we see that, Your Justices, that the applicant in today's case is the holder of the right. So that means the applicant in today's case is expected to maintain or to protest peacefully throughout their protest. So, and we submit to Justices that side.
In what way was the protest not peaceful? Was there any violence? Were there weapons?
Thank you so much for your question, Your Justice. In answering your question, Your Justice, side applicant in today's case was not peaceful, as we see that they actually dragged dustbins, placing them in front of the school's gate and also on public roads, not only disrupting road users, but also disrupting teachers who are going inside the school premises to teach, and the learners going inside school premises to learn, which we see indirectly, side applicants in today's case created a non-conducive learning environment for the betterment of the rest of the learners in today's case, as they didn't comply.
Is that really violent? Because the purpose of a protest is to disrupt. If a protest would just go by unnoticed, they wouldn't achieve the goal, which is to get the school to change the code of conduct. So does having those dustbins be in the way of the entrance or disrupting traffic, does that make it violent?
We submit to this honorable court, Your Justices, that side applicant in today's case could at least picket it in a much more reasonable manner, or rather than just dragging dustbins and furthermore banning dustbins in today's case. And we see that side applicants did not exhaust all of their internal remedies, less restrictive means to be exact, Your Justices. If it answers your Justice's question, I would like to move on. And we submit, and we as side applicant acknowledge that the Gatherings Act itself states it is a law that's the law to peaceful assembly, law that not only aims to make protest peaceful, it also ensures that people exercising their right to protest do not unnecessarily infringe on other people's rights. And the law should make protest possible, but also regulates them in terms of being peaceful. And we see that since side applicant in this case, in today's case, didn't have no means of being peaceful, then indirectly or directly, they lose their constitutional protection over their right to peaceful assembly. Moving on, your justices, to the constitutional level of Section 17, we submit that Section 17 of the Bill of Rights in the Constitution guarantees, and we admit that Section 17 guarantees that everyone has the right to peacefully and unarmed to assemble, to demonstrate, to picket, and also present petitions. And the guarantee, however, your justices, the guarantee in this right is not absolute. Exercising the right to protest, evenly peaceful or unarmed, can infringe upon the fundamental rights of other human beings. Since we see that there was a confrontation with the road users, not only we as side respondent into today's case, we don't know whether the road users were rushing to an important meeting or a life-changing occurrence, or maybe a life-changing decision process. So we submit also at an international level, Article 15, subsection 2 of the United States Convention on the Rights of the Children. And we believe that side applicants in today's case interpreted this right in a wrongful manner, as they didn't continue to read the rest of the law. We submit that Article 15, subsection 2 of the United Nations Convention on the Rights of Children states, no restrictions may be placed on the exercise of the rights to assembly other than those imposed in conformity with the law, and which are necessary in a democratic society in the interest of national security or public safety. And we see, your justices, that since the respondent forgot this part of conformity with the law, then we see that applicant didn't abide with conformity with the law, then this further drives that side applicant in this case, strike was actually unconstitutional as it infringed on the rights of other people, as previously stated. As I said, that it led to a confrontation with the road users, also led to a confrontation with the teachers entering school premises to teach and learners entering school premises to learn. So, your justices, we also submit that side applicant in today's case could have used less restrictive means to even protest against the school. In today's case, we submit that maybe the applicant could have maybe written a letter or maybe talked to the prefects or the RCL of the school to maybe find a better solution than what distraction they've caused in today's case. And in conclusion, your justices, we as the counsel of the respondent have shown and stated that the school's code of conduct is constitutional as it brings about discipline that should be implemented by the school concerning transgressions by the learners. And we've proven that this promotes self-discipline and encourages good behavior. And with that being said, your justices, we therefore pray for the following orders. Number one, we as the counsel of the respondent pray that Section 4 of the school code of conduct be deemed constitutional. Number two, we further pray that the SGB's decision to suspend the applicants in this case to be seen as constitutional. And with that being said, your justices, I would like to take my leave.
Okay, thank you very much for that, counsels for the respondent. If the applicants are ready, I believe you would have reserved 2 minutes for rebuttal, given that you both spoke 9 minutes each. So when you are ready to...
Thank you so much, your justices. The counsel for the applicants would like to refer to Counsel Atandile's statement stating that they could have expelled the learners for carrying cell phones. Your justices, that just proves our point as the applicants that the respondent truly does not actually care about the learners' rights to basic education, as they were willing to actually take more extreme measures to deal with such a trivial matter as a cell phone carriage. To go on further, your justices, nowhere in the state of facts does it state that the applicants were part of the learners who were using their cell phones in the classroom. Therefore, in no way did that disrupt the education of the rest of the class. With that being said, we submit that the learners should have been allowed to progress with the classes for that day. Your justices, Counsel Lubanga stated that the applicant did not exhaust all other less restrictive measures to get their point across. Your justices, my co-counsel had already mentioned that there was resistance in terms of with the whole school, that nobody, however, that the school was not willing to listen. The mere fact that the school did not grant the learners a hearing means that the school was not willing to hear anything that the learners had to say. Therefore, this was the only other way to have their voices heard. I mean, why then would the principal now come and organize a meeting after the strikes? Why not grant them the hearing? Why not go with the right procedure first? The respondent only took action after the learners had taken the only other harsh way for them to be heard. As the court pleases, I'll take my leave.
Thank you for that quick and pointed rebuttal. We'll then call upon the respondents to do sir rebuttal.
We as the respondents, as we do our rebuttal, we have identified two issues that the applicants in the matter have said. Number one, they say that when Sfiso Cele's phone fell out of pocket as it was off, it did not cause a distraction. Number two, they say that the school was not willing to listen to the learners as they were not with the school's code of conduct. With that, your justices, we submit that when Sfiso Cele's phone fell out of the pocket, obviously there was teaching going on in the classroom as the teacher was in the classroom. So your justices, the teaching time, when Sfiso Cele's phone was confiscated, the teacher had to stop teaching and attend the matter of confiscating the cell phone and not using the teacher's time effectively. So that, your justices, we believe that it disturbed learning in the school grounds, your justices. And your justices, we submit that the learners, in this case, your justices, the school was willing to listen to the learners' grievances because Mrs. Koza sent a WhatsApp message to the parents stating that there will be a meeting to discuss the way forward of this situation, your justices. So the learners blocked the entrance of the people so that the meeting could not take place. Your justices, I would like to remind this court of the importance of following the rules. Your justices, policies establish rules and regulations to and ensure that the school environment is safe for students, teachers, and school staff. School policies create a productive and conducive learning environment. Learners cannot do as they please, your justices. They need to abide by the school rules. With that, your justices, we submit the MEC of Education of KZN and other versus the Pillay case, which states that rules are important to education. Not only do they promote an important sense of discipline in children, but they prepare them to the real world, which contain even more and more strict rules than the ones that are adopted in the school. So your justices, with that, we say that this code of conduct prepares the learners for the future. For example, when you are in a job, your justice, and you do not act according to your expectations, then you might get suspended in the job, and this will be a life-changing decision to you, as you will be more exposed to hunger, drought, and famine. With that being said, your justices, I would like to take my leave.
Thank you very much for that, respondents. I think we can close the session, but before we do so, I don't know if my co-judges have any concerns, but more importantly, any comments or feedback to give to the learners.
There's nothing much from me, yes, other than just to encourage the teams. Yes, I must say that I was really impressed that high school students know the law to such a greater extent. Yes, I'm really proud of you guys, and I would like to encourage you guys to continue doing well. in your school and just focus on your matric exams and then get university entrance. And I believe that since you guys are doing mood, you probably want to pursue law as a career. And yes, you would know that, well, when you get to university level, you would see that it's actually a very, very nice degree to study. Of course, it will be tough. And yes, good luck, guys, in the future. Yes, thank you. That's all from me.
I would like to congratulate you all. And I think you all should be very proud of yourselves. You showed up, and what you're telling us and presenting here today is knowledge that I was not expecting to hear from high school students. Your application of the law, the concise nature, in fact, you went as far as referencing the charter and even international law and international human rights law. And I'm like, you guys are just incredible. I mean, I had most of international law and even the charter and all those things when I was almost done with undergrad law. And you are in high school already doing this. So your future is bright and you should all be very proud of yourself.
Exactly. Yes, I doubt that the time that I was in high school, I could argue very efficiently and successfully as you guys did. Yes. So if ever I was perhaps one of your opponents, you definitely would have more blow to my face.
I think I definitely agree. I think all of us were very thoroughly impressed with the knowledge of law that you guys shared. And more importantly, its application for high school students to know the requirements for restricting a right and really walking us through the case law. I was very impressed for both applicant and respondent. I'm not going to repeat all of the wonderful things that my co-judges have said, but what I will do is give you a little bit of stylistic feedback, which is that I think both of you were very structured and easy to listen to. I think the only thing that you need to work on would be adding that same structure that you have in your speeches to when you're answering questions. So when you're answering a question that a judge has, maybe, and most of the time I think you did it, but include something like the Schools Act, a case that you've been citing, the charter, whatever it is, and use that a bit of structure to answer when you're answering. And always tie back the answer to whatever the main argument you are making is, so that the question isn't just hanging in the air. But overall, I think you guys did a very good job at using and applying the law and also responding to each other. It's a very big thing, I think, at a high school level to be doing what you're doing and doing it so well. So I'm very impressed with you guys, and I hope to see you in the further rounds. I wish both the applicant and respondent very good luck ahead. Okay, with that being said, I do think the next session needs to start, so we need to leave the room. If the other judges have no other concerns, I'd like then to just wish you all the best and enjoy the rest of your day.
Yes, nothing further from me.
Same here.
Okay, goodbye, everyone.
Bye.
Hey, team.
Yo, this team just left.
decide among yourselves how much time the applicants want to take. It is recommended that each speaker takes between 8 to 10 minutes, but you can also reserve some time for rebuttals after the respondents have finished their submissions. So without wasting much time, if you're ready, applicants, we're ready for you.
Michael, can maybe the teams each write their surnames in the chat? Just
yes.
Easily, yes.
Yes, as Judge Baum has requested, if you can please just write your surnames. Let's say applicant 1, your surname, and applicant 2, your surname as well. Same for the respondents as well, please, just in the chat box. Otherwise, you can just announce it when you start speaking. Okay, yeah, I think we have everything now. So applicants, if you're ready, we are ready for you. Just are you there, team 117? We're ready for you, applicants. You can address the court whenever you're ready.
As it may please the court, I am Supervisor Njali. I appear as the first counsel for the applicants. I appear together with my learned co-counsel, Nonduduzo Tangazela. There are two issues that lie before this court. The first being the unconstitutionality of Section 4 of the Schools Code of Conduct, which is found to be violating our clients' rights to privacy and basic education in accordance to Section 14 and 29 of the Constitution. The second issue is that the SGP's decision is unconstitutional and violates our clients' rights to peaceful assembly in accordance to Section 17 of the Constitution. As the first counsel, I will be arguing for 9 minutes, tackling the first issue. My co-counsel shall proceed for 9 minutes, tackling the second issue, and we will reserve 2 minutes for rebuttal. As a starting point, counsel for the applicants request to bring the two following points before the court. The first point being that the Constitution of the Republic of South Africa is the supreme law of the country as it is stated in Section 2 of the Constitution. This means that any other law or rule that is found to be violating the Constitution must be amended to remove the unconstitutional parts or declared invalid. Your Justices, the first points that I'll be arguing upon is the irrationality of Section 4 of the Schools Code of Conduct. The School Code of Conduct might have been promulgated through the participation of the SGB, the educators, the learners, and parents. However, its implementation is too broad, hence now it's found to be violating our clients' constitutional rights. In order for us to ensure that decisions made by our courts are respected, I would like to refer you to the matter between MEC for Education versus Pillay, the case of 2007, number 51, at paragraph 6, wore a gold note stud in respect to her religion. Now, I am aware that religion and education are distinguishable. However, the principle of case precedence still stands. Your Justices, I would like to refer you to the matter between Head of Department, Department of Education, Free State Province versus Bolcom High School, the case of 2014, number 228, at paragraph 58, where it is stated that state functionaries, including schools, may do what the law permits them to do, but they may not go beyond what is required by the law. The court further stated that the principal, as the head of the school, has prerogative to ignore the policy of the school governing body if it is unconstitutional. Your Justices, it is with respect that I submit that the whole world is moving towards fourth industrial revolution. The school must create mechanisms to integrate the use of cell phones at school. I also humbly submit that learners should be encouraged to bring their cell phones to school in order for them to be able to record lessons in class and download material that may assist them get a better understanding of their schoolwork. However, this does not mean that discipline should not be enforced. Discipline can be enforced by instructing these learners to only use their phones for the purpose of teaching and learning, and for them to ensure that their cell phones are kept on silence at all times. The Section 8A of South African Schools Act provides for random search and seizure. However, it clearly states that the principal or his or her delegates may at random search a group of learners or the property of a group of learners for any dangerous object or illegal drug, but not a gadget like a cell phone. Therefore, I humbly submit as the counsel for the applicants that it is an unreasonable suspicion that was established by the principal's order of Umjondolo Combined School. It has invaded our clients' privacy and has infringed their constitutional rights. Your Justices, I would like to outline the guidelines of search and seizure practices of South African schools, where it is stated that searches are conducted after considering all relevant factors, such as A, the best interest of the learner in question, B, the safety and health of the learner in question, and C, reasonable evidence of illegal activities. However, it is important for any search to meet the reasonableness test. That is, it must be based on credible information and carried out in a reasonable and sensitive manner. Strip searching all learners when just one person has dropped his cell phone from his pockets would be hard limited the reasonableness test. It is said that whenever principals can, they should determine in advance whether a particular search is going to become a police matter and would they want the learner to face criminal charges or potential conviction. However, Your Justice, I humbly submit that our clients have just brought their cell phone to school and it is not a matter of the police. It is with respect that I submit that education is central to every child's development. It is a key to a better life. It has been locally populated that education is a bridge from misery to hope. It is used as a tool in modern society and is a bulwark against all poverty. By suspending our clients for the rest of the year, the respondent has violated our clients' rights to basic education in accordance with Section 29, subsection 1 of the Constitution, which states that everyone has a right to basic education, including adult basic education. Your Justices, I would like to refer to the matter between the Federation of Governing Bodies for South African Schools versus member of the Executive Council. The case of 26 stated that public schools are not refined spaces only for the bright, well-mannered, and financial well advance the parochial needs for immediate learners. I humbly submit that our clients, just because of the cell phones that they brought to school. Your Justices, I would like to state that Section 28, which is the child's rights in the Constitution, states that a child's best interests are of paramount importance in every matter. In paragraph 7, it is provided that these learners are between the ages of 14 and 17. They are still minors, hence they still need protection and guidance of the law. I humbly submit that the respondent had already achieved its purpose of discipline by confiscating their cell phones, but as going as far as for suspending them for the rest of the year, that decision is way too broad, and I submit that it violates our clients' rights to privacy and basic education. The Constitution recognizes dignity as an inborn right to Section 10, which states that everyone has the right to have their dignity protected. Dignity can be said to mean respect of one's rights, but how can the applicants have a sense of respect and self-worth if they are suspended from school for the rest of the year? Your Justices, I humbly submit that the SGP's decision is unconstitutional and has violated our clients' rights to basic education, privacy, equality, and peaceful assembly. If there are no further questions to be asked, I request the leave of this court to hand over to my co-counsel as she's to further elaborate.
Thank you very much, Counsel. We will hear from your co-counsel.
As it may please the court's justices, for the sake of the record, my name is Nontujuzo Dangazelo. I appear as the second counsel for the applicant in this matter. Since my learned co-counsel has dealt with the first issue, I will proceed on centering the second issue that the SGP's decision is unconstitutional as it violates the learner's right to peaceful assembly in terms of Section 17 of the Constitution, as well as the unconstitutionality of corporal punishment in terms of Section 10 of South African School Act. Your Justices, it is accurate to articulate that even the balancing test does not prove it right. Education has more value than cell phones being carried to a school that doesn't permit them. Therefore, I can confidently say that the school's code of conduct is unreasonable and unjustifiable according to all the evaluation done at Section 36 of the Constitution, Your Justice. Any law that is not in line with the Constitution is invalid. Paragraph 2 of the fact stated that the learners are punished even for small transgression and corporal punishment is enforced. It is my submissions, Your Justices. Section 10, subsection 1 of South African School Act, number 84 of 1996, stating that no person may administer corporal punishment against a learner at a school. Your Justices, if I may refer you in the matter between Christian Education versus Minister of Education held on the Constitutional Court case number 4/00 on 2000. The Constitutional Court stated that corporal punishment violates many children's rights, including their right to dignity, freedom and security of the person, and their right to be protected from maltreatment, neglect, abuse, or even degradation. With respect, I submit to Justices, counsel for respondent must review South African School Act number 84 of 1996, Section 9, suspension and expulsion from public school. It states, subsection 1, a governing body may, on reasonable ground and as a precautionary measure, suspend a learner who is suspected of serious misconduct, but may only enforce such suspension after a learner has been granted a reasonable opportunity to make representations to it in relation to such suspension. Justices, if I may refer you to the hypothetical case 2021, paragraph 6, it states that the learners are suspended from the school with immediate effect. It is my submission, Your Justices, that my client's right to adhere to disciplinary proceeding was violated by the respondent, as stated in subsection 1A, inserted by section 2A of Act number 24 of 2005, stating that a governing body must conduct disciplinary proceedings in the manner contemplated in section 8 against a learner within 7 school days, Your Justices. Therefore, I humbly submit that it was irrational of the school and unconstitutional of it to suspend my clients without them being adhering to disciplinary proceeding, Your Justice. The SGP's Code of Conduct is also unconstitutional. Section 17 of the Constitution states that everyone has the right peacefully and unarmed to assemble, to demonstrate, and to present petition. It is my submission, Your Justices. Section 39, subsection 1B of the Constitution states that when interpreting the Bill of Rights, a court must consider international law. The United Nations Covenant on the Rights of the Child, Article 15, paragraph 1, states that status parties recognize the child's right to freedom of expression in terms of Section 18 of the Constitution, as well as the child's right to peaceful assembly in terms of Section 17 of the Constitution. Justices, if I may refer you to the guideline of freedom of assembly of Africa, stated in paragraph 17 that the assembly should be deemed peaceful if the organizers are expressing their peaceful intention. Therefore, as it is stated in hypothetical case of 2021 paragraph 9, that the group was formed spontaneously. Justices, if I may refer you to the matter between Mlungwane versus the state held at the Constitutional Court, case number 32/18 on 2019. It was stated that it is open to a convener to invoke a defense that the gathering formed took place spontaneously. Justices, also, if I may refer you to the matter between South African Transport and Allied Workers Union versus Gavers, also known as the Satau case on 2013. As the Constitutional Court stated in paragraph 52, that everyone has the right to go out and assemble, demonstrate, as well as to present petition for any lawful purposes, Your Justice. And the very same case, the court stated in paragraph 62 that spontaneous and organized demonstration and protest are an important way in which people can express themselves. Furthermore, I submit that protesting serves as an important instrument for democracy and for people who are oppressed in this country. Justices, paraphrasing Section 36, it states that there must be general application of the law. It must be within the spirit of the Constitution and taking account all relevant factors, including the nature of the right, the importance of the purpose of the limitation, the nature and extent of the limitation, the relation between the limitation and its purpose, as well as less restrictive means to achieve the purpose. Justices, it is my submission to you that there could have been a less restrictive alternative way by saying the learners should not use their cell phones during teaching hours. But banning them altogether, whether on or off, cannot be sustained in our Constitution. Justices, arguments to that effect, Section 36, subsection 1E of the Constitution. I humbly submit that punishment given to the applicant is extremely harsh, as it does not coincide with subsection 2 of South African School Act, stating that no law may limit any rights entrenched in the Bill of Rights. Justices, if I may refer you in the matter between Antonio versus Governing Body of Settlers High at paragraph 17, held at the Constitutional Court on 2002, where the Constitutional Court stated that a question should be asked whether the prohibition is aimed at promoting positive discipline or not. While we note that the learners are still young, and Section 28 provides the protection of such learners. Justices, it is my submission that if the school is still...
You mentioned a position just now about improving the quality of studies. And I remember from the facts of the case that this particular school has always been in chaos. And when the new head of school came, she put in measures such as this that you are arguing, especially. And I mean, the facts also even states that students were distracted by their phones, and these were some of the measures that they put in place. So are you saying now that these measures that were put in place that increased the performance of the school exponentially are not measures that you believe are too extreme in your opinion?
Thank you, Justice, for the question. As I earlier submitted, Your Justice, that according to subsection 1A inserted by section 2 of Act number 24 of 2005, A governing body ought to provide the learners with disciplinary proceedings in the manner contemplated in Section 8 against a learner. And also, South African School Act clearly states that a learner must be suspended by the HOD, not by the school governing body, but not more than a week, which is violating their right to basic education, Your Justice.
But these same school guidelines already state that when there is a violation, the person must be suspended for the rest of the year. So how do you bring this, how do you balance it between the 1 week suspension you're mentioning now and the 1 year suspension that's the act already stating?
Thank you, Justice, for the question. If I may refer you, Justice, to the hypothetical case 2021, paragraph 13, it is stated that the SGB suspended the learners for the maximum period. That maximum period was 1 year. And according to South African School Act, a learner may be suspended from school, but not more than a week, Justices. So the school acted unconstitutional to violate my clients for the rest of the year.
Okay, thank you. You may continue.
Thank you, Justices. As I was submitting that, if the school is still refusing our clients' civil right to privacy, right to education, and right to peaceful assembly, that would be aimed at freeing my clients' right to better education, as the preamble emphasizes, as well as if this court will let this unlawful SGB decision, that will mean more than us will suffer what these 6 learners are suffering, which is the infringement of their constitutional rights, which are violated by the respondent. Counsel for the applicant submits that it has made a solid argument in favor of these learners and prays to this court that the court will find in its favor and upholds this dismissed with cause.
Thank you very much, counsel. If the respondent is ready, we're ready for you.
Good afternoon, Your Justices. I am Tapiwana Shematumbura, and I will be counsel for the respondent in the case before the court. I reserve 10 minutes for myself and a further 10 minutes for my co-counsel, Remo Amahetimketi, for his submissions. As it pleases the court, I would like to start by reciting the legal facts and the legal question at the case presented at hand. In the case before the court, the past section 4 of the school's code of conduct of Njondolo Combined School is not unconstitutional and does not violate the applicant's rights to privacy and basic education in terms of section 14 privacy and 29 education of the Constitution of the Republic of South Africa, Act 108 of 1996, hereinafter referred to as the Constitution. Furthermore, the school governing body's decision to suspend for the maximum period the applicant, all minors, is not unconstitutional and does not violate the applicant's rights to peaceful assembly as per section 17 of the Constitution. As counsel for the respondent, we submit that the relevant sections did not infringe the applicant's rights and that this was in fact a justifiable limitation in terms of section 36, the limitation clause of the Constitution. If it pleases the court, I would like to go on to my first submission of the day. Child's best interest. Njondolo Combined School, situated in Braamfontein, Gauteng, who has for a number of years had a problem with discipline and high absenteeism amongst learners and the teachers alike. Cell phones were actively in use, and the pass rate was a mere 53%. Cell phones were actively used in the school and were a major distraction and an infringement on other learners' rights to education as per section 29(1) of the Constitution. Everyone has the right to basic education, including adult basic education. In accordance to section 28(2) of the Constitution, a child's best interests are of paramount importance. The new principal appointed in 2019, Ms. Koza, managed to achieve, after only a year, a matric pass rate of 72%. This provided an increase of 19% and an addition of 10 learners achieving the bachelor passes. Cell phones at the school did remain a problem and were not conducive to the learners' needs. The efforts of the respondent in implementing the new measures is to try and improve and shift to a conducive environment, which is in the child's best interest. And the improvement in the pass rate shows that the new school dynamics are for the benefit of the child. If the respondent has no further submissions on this point, so unless the court wishes to be addressed on anything particular, I would like to go on with the next issue.
Counsel, before you proceed, the applicants did argue that even though they agree that regulating the use of mobile phones in school is important, the complete prohibition they find is quite overbroad, because the essence of regulating the use of cell phones is not to prohibit completely the learners' access to mobile phones, assuming they want to contact family or for emergency purposes. Why is it legitimate that the school bans the use of mobile phones completely? It's not even a restriction of the use, but a complete ban on a person having in their possession a mobile phone. How is that fair?
Your Justice, as your concerns were to be answered in the following submission of Section 36, the limitations of right. But as to address your Justice concerns, it is important, as this is a school that is situated in an inner depressed city. It is a CBD. The school has a problem already with the functionings and had a problem with the behavior in the students. And therefore, the respondent felt it was necessary to completely prohibit the use, the possession of cell phones in the school. So if that answers your justice question, I would submit to go on to Section 36, the limitation of rights.
Now you may proceed, Counsel.
As per subsection 1 in the Constitution of Section 36, it states that the rights in the Bill of Rights may be limited only in terms of the law of general application and to the extent that the limitation is reasonable, justifiable in an open democratic society based on human dignity, equality, freedom, and taking into account all relevant factors, including A, the nature of the right. In the case before the court, the nature of the right is restrictive, but serves to ensure that learners comply with the school code of conduct and create and preserve an adequate and safe, improved education and learning environment. B, the importance of the purpose of the limitation. The importance of the purpose of this limitation is that it promotes a safe and productive and healthy school environment that is disciplined. C, the nature and the extent of the limitation. The nature of the limitation is in the child's best interest. And the limitation is only extended on the learner's possession of cell phones on school premises. Outside the school, on holidays, during weekends, or at home, the learner is not obliged to adhere to the school code of conduct. D, the relation between the limitation and its purpose. The limitation ensures that there is discipline and order in the school. The purpose serves to create and inspire a high standard of education, a safe, healthy, and productive environment for education and learning, and to deliver on all the learners' rights to education. Thus, both the purpose and the limitation serve in the best interest of the child. And finally, E, less restrictive means to achieve the purpose, which was part of your Justice's question. There is no other less restrictive means to achieve this purpose, as the applicants were given notice of the code of conduct and still persisted to its violation, as well as the code of conduct provides a gap in which the measures can be taken for learners which do have special needs without breaking the order of authority. The school, in this case, the school and the staff act as in loco parentis for the learners, acting parents for the learners. Exemplar criteria: a drop-in safe to store phones that will be given to to store phones at the admin office that will be given in as the learners enter the school and given up. and given back to them in the afternoon as they exit the school. And furthermore, the school provides admin block, whereas is mandatory for every school, has cell phones in which the learners can use to get in contact with their parents if need be. The code of conduct implemented by the school weighs between the needs of the learners while also leaving space for those with special needs. To address the applicant's concerns on equality, I'd like to divert the court to a locus classicus, to a locus classicus, Amar versus Amar, in which the legal definition of equality was given by the judge and emphasized as those who are alike be treated alike, and those who are different be treated different. As per subsection 2 of section 36, the limitation of rights, except as provided in subsection 1 or in any other provision of the Constitution, no law may limit any right entrenched in the Bill of Rights. And as the respondent has adhered to section 1 of to subsection 1 of section 36 of the application, the limitation upon the applicant's right were just, equal, were just and fair. If it pleases the court and the court has no need to be addressed upon anything further, I would like to go to my third submission.
Council, you may proceed to your third submission, but your time is almost up, so please be as brief as possible.
Yes, Your Justice. The regulation of cell phone use in the school. The active use of cell phone promotes bad discipline in the school and infringes on the learner's rights to education as contained in section 29 of the Constitution. Failure to act by the school would not be in compliance with section 28 of the Constitution. After a consultative process, the school governing body did introduce a code of conduct regulating school phones. And to highlight the school code of conduct, if we check on chapter 2 of the SA Schools Act, in section 8, in section 11, the representative council of learners, it states that every school, every representative council of learners at a school must be established at every public school enrolling learners 8th grade or higher. And as Umjondolo Combined School enrolls learners who are 8th grade or higher, it is then deduced that they do have an active RCL council, which is there to voice the concerns of the learners. Therefore, the learners were included in the consultative process, which was taking and the passing of the code of conduct. To go on, section 4 of the code of conduct prohibited the use of cell phones on school premises, as stated earlier, any learner found in possession of the school or the phone on school premises would be liable for suspension. Your Honor, Your Justice, Braamfontein is a depressed inner city area, a CBD, with little available facility for sports and recreation. Schools located within this area are affected by high crime rates. And thus, by regulating the possession of cell phone uses on the school premises, this also is in compliance with section 24A of the Constitution. Everyone has a right to an environment that is not harmful to their well-being or health, To leave Your Honor with the locus classicus upon to leave the justice with the locus classicus upon deciding the case. Anthony versus the governing body at Settlers High School, 2002, in which the judgment emphasized the question should be asked in this regard, whether the prohibition is aimed at at promoting positive discipline, in which case this code of conduct does stick to that, and whether the non-compliance to therewith justifies punishment or some form of sanction, in which the code of conduct did include and did state that this would. The judgment further emphasized that this requires a spirit of mutual respect, reconciliation, and tolerance, of which the school governing body kept in all the decisions that are made upon that. To leave the quote, to take my leave with the quote, disciplining yourself to do what you know is right and important, although difficult, is the high road to pride, self-esteem, personal satisfaction. This is Margaret Thatcher, known as the Iron Lady.
Thank you very much, counsel. You will hear from your co-counsel. Council, we cannot hear you.
I'm about to start.
Okay, no, my apologies. I thought you had already started speaking.
No. Okay. Good afternoon, your justices. I am Nsmcc, counsel for the respondent, and I would like to reserve 6 minutes for my submissions and 4 minutes for rebuttal.
Counsel, since you are the respondent, you don't actually get a rebuttal. The rebuttal is only for the applicants. So you would have to make all of your submissions now.
Okay, all right, that's not a problem, Justice.
All right, please proceed.
Okay. The first submission the respondent would like to make to your justices is with regard to the suspension of the applicant. The South African Schools Act, number 84 of 1996, section 8.2, and the South African Schools Act will be hereinafter referred to as the SA Schools Act. In section 8.2 states that a code of conduct must be aimed at establishing discipline and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. And section 8.4, nothing contained in this act exempts a learner from the obligation to comply with the code of conduct of the schools attended by such a learner. Now, the first submission that the respondent would like to make to the court is that in no way has the respondent in no way has the respondent's policies and disciplinary actions been attacks on the learners or to make the learning process difficult and life-draining for the learners going to Jololo Combined School. The code of conduct was meant to instill order into the school in a time where there was pure anarchy. The teachers didn't want to be at school, the learners didn't want to be at school. This was seen through the high rates of absenteeism. The learners' disruptive conduct infringed on the human rights of the teachers and on the human rights and dignity of the teachers, and further disrupted the learning process, which was entirely not in the child's best interest. The disruptive energy created by cell phones, as has already been discussed by my co-counsel, had to be dropped in order to set a bar from which the school would operate, a bar from which the school can instill some sort of order so that it can get teaching going again. The respondent submits that the means that it used were restrictive, but no other means were available. However, the respondent sympathized with the frustration caused by these restrictive means. Hence, the respondent held constant consultative processes.
Did you just admit that the means were strict, but there were no other means available?
At the time, Your Justice, the respondent submits that at the time that the respondent came into power, the means were restrictive indeed, but no other means were available at the time.
What means are we talking about here, please?
May you please repeat the question, please, Your Justice?
You're mentioning means that no other means were available, and I'm asking what means are you referring to?
I am referring to the code of conduct, Your Justice, which was provided in the hypothetical case, which the respondent would like to quote.
All right, fine, thank you. You may proceed.
Oh, okay, all right, thank you, Your Justice. Held constant consultative processes and conciliatory processes.
Counsel, I have a bit of an issue with your argument. I mean, the applicant has argued, for instance, that even though they understand that disciplinary proceedings are important, that your clients suspended the clients of the applicants without even giving them a hearing. They were suspended without allowing them to even state their case in any way, and that the suspension in itself went way beyond the 7 days that is allowed under the South African Schools Act.
Your
Do you have any
Justice,
response for the applicants in this regard?
yes, indeed, and the respondent does have a response it would like to submit. As per the SA Schools Act, the respondent would like to refer the court to the SA Schools Act, Section 9, suspension and expulsion from public schools. Subject to this act, Section 9(1), subject to this act and any applicable provincial law, the governing body of a public school may, after a fair hearing, suspend a learner from attending the school. If the respondent would like to refer the court to subsection 9(b), pending a decision as to whether the respondent is to be expelled from the school by the head of department. In section 9(a), as the SA Schools Act describes the suspension from the public schools as a correctional measure for a period not longer than 1 week, and then states all. And then we move to section 9(b), pending a decision as to whether the learner is to be expelled from the school by the head of department. In section 9(b), indeed, the maximum period is 1 week, which was adhered to by the respondent at a different time of suspension, but with regards to what the applicant has stated. Pending a decision as to whether the learner is to be expelled from the school, the suspension is allowed to be longer than 1 week, as it is pending a decision to be expelled from the school by the head of department. The reason for the decision to be pending a decision as to whether the learner is to be expelled from the school is because the learner was challenging the code of conduct, which was implemented in the school in order to try and instill order into the school. Because the use of cell phones at the time, the court would just like to refer the respondent would just like to refer the court. The respondent would just like to refer the court to the demographics of Braamfontein at the moment and refer the court to the time, to the condition of the school at the time at which the respondent came into power. As already stated, the learners didn't want to be at school. The teachers didn't want to be at school. There was a high amount of disruptive energy, and the use of cell phones further fanned the disruptive energy and the anarchy that was within the school. Hence, it was so important for the respondent to actually limit or prohibit the use of cell phones so that the learning process may be able to continue, so that the child's best interest could be achieved. The respondent would like to further submit that the disciplinary action taken by the respondent is with regards to section 8 code of conduct subsection 4, that nothing contained in this act exempts a learner from the obligation to comply with the code of conduct of the school attended by such a learner. And furthermore, the respondent would like to submit to the court that because the code of conduct was in the child's best interest, therefore the code of conduct was in line with the Constitution as an organ of state in order to promote human rights to dignity, openness. If the court would bear with me, please.
Council, while you look for the provision, just know that the time is almost up, so you can try to wrap it up within the next 1 minute, please.
Okay, the respondent would like to submit to the court that the applicants had no reason to not comply with the code of conduct of the school, as the code of conduct was in the child's best interest, thus meeting the chapter 1 founding provisions of the Constitution, being achievement of equality and the advancement of human rights and freedoms. Now, firstly, it does seem as though how the applicant has presented the case makes it seem as though the respondent has violated the human rights of the applicant. However, what the respondent would firstly like to submit is that
With regards to privacy being infringed on by the respondent would like to refer the court to Justice Ackerman in the Bernstein versus Bester case, where Justice Ackerman extensively discussed that unless there are certain actions within the personal sphere or certain possessions within the personal sphere which extend negatively to communal relations and activities such as business and social interaction, and in the case that lies before the court today, communal relations would be school, the learning environment or the school. The privacy of an individual cannot be invaded. The respondent would like to submit to the court that the use of cell phones by the learners and the applicants within the school was extending negatively to the learning environment as it was fanning the disruptive energy and making it impossible for the learning process to take place. And therefore, the respondent was justified in its limitation of the applicant's right to privacy, applicant's right to privacy. Now, when it comes to the gatherings, the gatherings, firstly, what the respondent would like to submit to the court is that the respondent did not take any action against the gatherings that took place. Instead, the police went and arrested the applicants in that case. And therefore, whatever qualms the applicant has with regards to the gatherings that it convened, the responsibility for those does not fall onto the school. However, it can lay its complaints or its case against the police, as the respondent took no action against them for the gatherings that were convened. Furthermore, what the respondent would like to submit to the court is that it is empathetic, humane, and understanding. The school's anarchy made it impossible for these policies to be impactful on their own. Therefore, the respondent used restrictive means to achieve the goal of discipline and improvement in marks, which is in the child's best interest. However, the traits of empathy and humanity were still present in the respondent's actions. There were constant conciliatory processes and consultative processes being held because the respondent understood the frustration brought about by the restrictive means. However, what the respondent would like to submit to the court is that the applicants the respondent's approach to achieving the child's best interest didn't meet was an approach that put learners out of their comfort zones, which is anywhere they can have a phone. The applicant.
I'll give you 10 seconds to wrap it up. We're way out of time.
The applicants, in their frustration, didn't acknowledge or appreciate the respondent's intentions and the means the respondent was using to actually achieve them, which was the child's best interest to improve the marks. Instead, the applicants were absorbed in their frustration, acted arbitrarily, and disrupted the conciliatory processes, whereas they could have used the RCL counsel to present their cases to the principal, as was discussed by my co-counsel, and in doing so, created a cancel culture was sparked from their actions. Before I take my leave, I'd like to leave the quote with a quote. There are, by Barack Obama. Barack Obama said, there are ambiguities. People who do really good stuff have flaws. The respondent's prayer for relief to the court, the respondent's prayer for relief to the Honorable Court is that issue an order in the following terms. That Section 4 of the School's Code of Conduct is not unconstitutional and does not violate the learner's rights to privacy and basic education in terms of Section 14 and 29 of the Constitution. And the school governing body's decision is not unconstitutional and does not violate learners' rights to peaceful assembly in terms of Section 17 of the Constitution. Thirdly, costs of suit. And lastly, further and or alternative relief. Thank you.
Thank you very much, counsel. The applicant, you're reserved 2 minutes for rebuttal, please.
As it may please the court, your justices, I would like to respond to the submissions made by the counsel for the respondents when they stated that the rights in the Bill of Rights can be limited in terms of
Section 36 of the Constitution, and as he did represent before the courts the relevant factors that are taken into account while limiting the rights, I would like to submit that there was no less restrictive means that were taken into consideration as Section 38E emphasizes. The justices, I would like to refer you to the matter between Antonio versus governing bodies of Settlers High, the case of 2002, paragraph 17, as my co-counsel has earlier stated, that a question should be asked if the promotion of positive discipline justifies sanctions given by the respondent. Your justices, I would like to state that Section 2 of the South African Schools Act provides that sanctions imposed on a learner must not be punitive, but must be intended to rehabilitate the learners. The counsel for the applicants further explained that discipline should be instilled at school. However, Justice, I would like to submit that discipline had been achieved by confiscating the learner's cell phones, but as going as far as suspending them, that too for the rest of the year, the school had acted unconstitutional, and that decision is too broad. And once again, I submit it violates our client's right to privacy and basic education in accordance to Section 14 of the Constitution.
Thank you very much, Counsel. We're out of time, but I will ask the judges if you can give just brief comments to the candidates. I will start first. I think both teams were brilliant. I enjoyed listening to you. I loved your arguments. I enjoyed the fact that you argued, backing your facts with the law and weaving it in such a skillful way that even, experienced advocates sometimes struggle to do. So congratulations to both teams. I think you were excellent, and I wish you the best. And I hope that we'll see you in the next rounds of the competition. Jonathan, if you have any quick comments, please.
Nothing special, just to congratulate the two teams. It was an interesting session, really. And yes, we had clarity. There were, at some point, I was even surprised the way they were dealing with those legal texts. Maybe one quick element for the respondent. As respondents, sometimes you are in a kind of difficult position because you just need to justify. You need to justify things that are not always clear. So maybe you can be more creative in the way to explain. You don't need to concede some elements. I think Justice Bam was at some point raising your attention or pointing you to something. No, you don't need to accept it but at the end of the day, it was a very interesting session, and all the best to the two teams. I think I'm looking forward to seeing you in the next stages. Thank you.
Yes, I would just congratulate the teams, and I say that you should be very proud of yourselves for showing up for this competition, and I wish you good luck as you proceed in the competition. Yeah, that's it.
Congratulations to both teams, and I'm sure you can leave the room now. The next session is just about to start, but we're looking forward to seeing you progress into the next rounds.
All right, so I would just like to introduce myself. I am Shiri Welifir. I will be the Chief Justice here today. And I'm just going to let my fellow justices introduce themselves to you as well.
Yeah, so good afternoon. I'm Justice Cabre, and yes, I will be sitting with my colleague judges for this session.
Good afternoon. I am Justice Shange, and I will be sitting for this session with my fellow colleagues. Thank you.
Thank you so much. Let's start with the applicants. Before we proceed with your submissions, I would just like the first speaker to type your name and surname on the group chat, so we can just keep a record of your name. Applicant, thank you. And now the second speaker. Thank you so much. All right, applicants, you can start with your submissions. I kindly ask that you turn the camera on. Thank you. Please also be advised that if you want to reserve time for rebuttal, you should tell me before you proceed, and also indicate how long which speaker will be talking for. Thanks. Okay, proceed.
May it please the court. In this case, we'll be arguing that Section 4 of the Schools Code of Conduct is unconstitutional and it violates the applicant's right to privacy. And that Section 70...
Counsel, sorry to interrupt. I just want to make sure you're not reserving time for rebuttal.
We are reserving 2 minutes for the rebuttal. The time
2 minutes for rebuttal.
Yes.
Okay, and for how long will you be speaking?
The time allocated to me is 7 minutes, and my co-counsel will speak for 11 minutes.
Okay, I just want to state that no speaker is allowed to speak for longer than 10 minutes. So is it possible that you could speak for 8 minutes and your co-counsel for 10 minutes? All right. Okay, perfect. Please proceed.
In this case, we'll be arguing that Section 4 of the Schools Code of Conduct is unconstitutional and violates the applicant's right to privacy, and that Section 17 of the Constitution of South Africa was also violated, and that Section 29 of the South African Constitution was also violated. I'll be dealing with Section 14 of the South African Constitution, and my co-counsel will be dealing with Section 29 and 17 of the South African Constitution. Section 14 of the South African Constitution states that everyone has the right to privacy, including not to have their home searched, their possessions seized, or the privacy of their communications infringed. We argue that Section 4 of the Schools Code of Conduct is unconstitutional as it violates the applicant's right to privacy. The principal further violated the learner's right to privacy when she ordered that the bags of all the learners are searched. Honorable Justices, as indicated earlier, these learners have the right not to have their possessions seized or to be searched. Counsel for the applicant is aware of the authority given to the SGB to adopt a school's code of conduct. However, contents of the code of conduct must be consistent with the Constitution of South Africa, which is the supreme law of the Republic. In this case, counsel for the respondent submits that Section 4 of the Schools Code of Conduct is inconsistent with the Constitution of South Africa, and as the Section 2 of the South African Constitution should be declared invalid. Counsel for the applicant also notes that the Constitution of South Africa provides a general limitation clause as Section 36 of the Constitution, which counsel for the applicant also notes that the Constitution of South Africa provides a general limitation clause at Section 36 of the South African Constitution, which provides for all the rights in the Bill of Rights to be limited only in terms of law of general application, and that the limitation is reasonable and justifiable in an open and democratic society based on human freedom, taking into account all relevant factors. We therefore submit that the applicant's right to privacy should not be subjected to this clause. We also submit that, according to Section 2 of the South African Constitution, the obligations imposed by the Constitution should be fulfilled. Therefore, the obligations imposed at Section 14 of the Constitution should be fulfilled. The school should not have banned the possession of cell phones altogether. However, they should have examined all the relevant factors, including the fact that possession of cell phones may have a positive impact on the learning process, including improved learning outcomes, increased engagement among learners, and an easier ability to keep students up to date with all the necessary schoolwork. Possession of cell phones can also help in a state of emergency, where, for instance, a learner is put in detention and will be dismissed a bit later than usual. The learner will need the cell phone to keep in contact with the parent or guardian in case the learner needs transport. We also argue that the SGB should amend Section 4 of the School's Code of Conduct in a way that less restrictive measures are implemented. The school should allow the learners to bring their cell phones with them to school, but will only be permitted to use their cell phones in the morning before the school bell rings, during recess, and after school. It will therefore be the responsibility of the learner to ensure that their cell phone is off during the lessons. Failure to do so, then confiscation will be necessary. I've stated my case. I'd like to hand over to my co-counsel to deliberate further, if it pleases the court.
Before your co-counsel proceeds, I would just like to establish with you, you said that it can improve learners' access to resources to facilitate the education process. Is there no other means on the school grounds by which they can access the internet, such as a computer lab, that could ultimately serve the same function as access to cell phones?
Your Justice, it is not clearly indicated that the school has access to such, which is the internet and all the relevant factors that you have mentioned.
All right, thank you, counsel. Co-counsel may proceed if my fellow justices don't have any questions.
May it please the court. My name is Sam Stanop, as my co-counsel has said, and I will be dealing with Section 17 and Section 29 of the South African Constitution. Section 39 of the South African Constitution states that the court must consider international law. In this case, we present to the court the International Convention on Civil and Political Rights, the ICCPR, that states that the right to peaceful assembly shall be recognized, and no restriction shall be placed against practicing these rights if an individual is unarmed. In the case of Satao and others against Gavas and others, it was clearly stated that everyone who is unarmed has the right to go out and protest with others, to assemble, to picket, and to present petitions to others for any lawful purposes. We submit that the applicants were unarmed during the protest and no violence was used. They had every right to protest and no one had the right to restrict them from doing so.
Counsel, just to interject there, I can hear your arguments that you're saying that your clients have a right to picket and to protest peacefully. So now my question to you is, was the protest peacefully?
Yes, the protest was peaceful, hence, and no violence was used, and the applicants were unarmed, and the case where.
So what about the fact that there was a fire which broke out later that evening?
From that scene, no culprits were identified, so we cannot crucify the applicants for the acts of vandalism where no one was seen, and no proof can prove that the applicants were the ones who vandalized the school.
Okay, so since you also said that your client has the right to picket and demonstrate peacefully, But it is also said that for you to exercise that right, you must give prior notice before exercising that right. But your client, as far as I'm concerned, provided no notice to exercise such right. They provided no notice that they will picket and demonstrate. So what do you have to say with that?
Justice, I will fully address this when I'm going on with the presentation.
Okay. Yes. Thank you, Counsel. You can continue.
Thank you. Anyone who restricts children from practicing their rights to participation, expression, and protesting, especially if those children are holding an entirely peaceful protest, may be subjected to criminal sanction. We must admit that protesting gives voice to the powerless. In some instances, protesting is the only mechanism that is available to fight against injustices and express legitimate concerns. Section 12, subsection 1 of the Regulation of Gathering Act, number 205 of 1993 states that if a gathering will be attended by 15 people or less, you don't need to give a notice. However, if the gathering will be attended by more than 15 people, you are required to give a notice. In this case, the protest of the applicant started with 6 people, and when the time went by, more people joined in. This justifies the reason of the applicant not giving a requisite notice. Hence, they had no idea of people who were going to join in. In the case of Mlungwana against the state, the court stated that a convener's mere failure to give a notice of an intention of holding a gathering should not be criminalized. Adding to that, it also stated that Section 12, subsection 1A of the Regulation of Gathering Act constitutes an unjustifiable limitations to the right to peaceful assembly. Adding to that, the process of the applicants was spontaneous. Therefore, it was not a criminal offense to join a protest where a notice is not given.
Okay, Counsel. So, considering the fact that your clients actually are the ones who started this picketing and demonstrating or protesting, if you want to call it. So, according to the facts, they built a wall with the dustbins. So, shouldn't that be seen as an infringement to the right to basic education of the other learners?
It may be that the applicants did infringe other learners' right to basic education, but we cannot consider the rights of other learners while we are not considering the rights of the applicant to basic education. The right to education must not be set for preferences or rather partialism, where one is seen more important than the other. In order for them to be noticed or to be heard, it was easier for everyone to suffer the consequences of not being allowed to attend school so that the school can see the importance of basic education.
Okay, thank you very much, Counsel.
Thank you. Learners were not supposed to be suspended at all. Hence, suspension deprives them a lot. Suspensions reduce the chance of learners completing school. Other disadvantages may include a learner obtaining a lower educational achievement, lower graduation rate, and lower college enrollment rates. The Code of Conduct was supposed to be implemented in a manner that promotes compulsory attendance. If ever suspension is considered, then proper procedures must be followed as stated in the South African Schools Act.
Okay, Counsel, I think I just heard you saying that now that learners were not supposed to be suspended. So maybe perhaps I may have missed this. What other alternative measures to suspension would you suggest instead? Since you say that learners were not supposed to be suspended, okay, so then what other measures of sanctions must be imposed on a learner which infringes such code of conduct?
Instead of suspending learners, they could have referred those learners to detention or given them a return warning if they are the first-time offenders.
Okay, thank you, Counsel.
Section 9 of the South African Schools Act number 84 of 1996 states that the SGP of a public school may, after a fair hearing, suspend a learner from attending school as a correctional measure for a period of not longer than a week. We submit that the applicants were suspended for a period of longer than a week. This proves that the disciplinary hearing was was not conducted in the manner that is contemplated in Section 8 of the South African Schools Act number 84 of 1996 against the learners. We cannot expect learners to succeed in life if we keep on denying them the right to basic education. Adding to that, the school did not send a suspension notice to the parents of the learners that states the reason of a learner being suspended, and no appropriate arrangements were made for provision of schoolwork for learners in the period of suspension. The applicants were immediately suspended for the rest of the year, meaning that they were not given the chance or rather the opportunity to be heard. We are against that, hence we believe that applicants are not endangering anyone's life or rather social well-being, and they have the right to be heard. In conclusion, our argument was based on the facts of that the applicants were unarmed during the protest and no violence was used. Adding to that, their suspension was not according to Section 8 of the South African Schools Act number 84 of 1996. Counsel for the applicant therefore requests this honorable court to declare that the High Court was incorrect in finding that the applicant's rights stated in Section 14, 17, and 29 of the South African Constitution were not violated, and that Section 4 of the Schools Code of Conduct is not unconstitutional. Secondly, to declare Section 4 of the Schools Code of Conduct and the SGB's decision as invalid and unconstitutional. And lastly, to declare the suspension as illegal, hence the disciplinary measures went beyond what is allowed by the South African Schools Act. If the court doesn't have any question for me, then I would love to descend and let my honorable friends to state their case, if it pleases the court.
Okay, just an administrative questions. Who is Ritabile Mulao? Is it the first speaker or the second speaker?
The first speaker.
Okay, and then the second speaker, it's Tando, right?
Yes.
Okay, thank you very much. Justice Olivier?
Thank you, applicants. I believe if there are no further questions from my fellow justices, we can move on to the respondent submissions.
Just before the respondent presents their case, have they inserted their name in the chat box? Because I can't see their names.
No, I also can't see the name. Will the first speaker of the respondents please insert the name in the chat box? Thank you very much. And can the second speaker do the same? Thank you very much. The first speaker, you may proceed with your submissions.
Good evening, my justices. Good evening, my peers. Me and my fellow counsel will be addressing the following sections of the Constitution of the Republic of South Africa. I will be addressing the following sections. Section 14, privacy provides. Everyone has the right to privacy, and Section 8, Code of Conduct. And my fellow counsel will be addressing Section 36, limitation of rights, Section 17 of Public Violence Act of 1996. Number 5, Constitution, Section 9, equality provides everyone is equal before the law and has the right to equal protection and benefits of the law. I will be giving the court a brief background on the matter before the court. I'll be taking for 6 minutes of the court's time, and my fellow counsel will be taking 7 minutes of the court's time. The question before the court is whether the learner's right to privacy and basic education has been violated. Number 1, in terms of Section 14 and Section 29 of the Constitution. Number 2, whether the SGB's decision is unconstitutional and violates the learner's right to peacefully assemble in terms of Section 17 of the Constitution. The parties that I represent today is the SGB of Mjondolo Combined School. If the court allows me to give a brief background about the matter before the court. Mjondolo High School is a public school in Braamfontein in the Gauteng province. For a number of years, the school had a problem with discipline and high incidence of absenteeism among learners and teachers, obviously resulting in poor academic performance by the learners. In 2018, they achieved a pass rate of mere 53%, meaning that only half of the matriculate were successful that academic year. In 2019, a new principal was appointed, Ms. Koza, with tough love as her motive. She wanted to restore discipline back in the school. At the end of the 2019 academic year, the school showed an increase to a 72% pass rate. And for the first time, 10 learners passed with bachelor passes. This, my justices, happened because of the measures implemented, such as punishment for any transgressions, and also the SGB implemented a code of conduct that prohibits the use of cell phones. A learner in grade 11 dropped his cell phone and it was confiscated by Mr. Mkisa, the teacher. The learner underwent a disciplinary hearing that resulted in the learner's suspension. After the learner seemed not to adhere to the code of conduct, Ms. Koza ordered a search of all school bags, whether on or off. They found 6 learners with cell phones whom was immediately suspended. My justices, the Constitution, Section 14, privacy provides everyone has the right to privacy. Under the Constitution is also another law that learners have to obey. When entering the school premises, some of their rights are limited, and every single learner, as well as the parent, is aware of that. For this reason, the counsel for the respondent, do not agree with the fact that it has been stated that the learner's right to privacy has been violated. The confiscation of the cell phone had a tremendous positive impact on the pass rate of the school. Therefore, it does not violate learners' right to basic education. The cell phone of the learners made it difficult for the teachers to do their job. With the learners' best interest at heart, took the right appropriate action.
Just to interject, counsel. Okay, so I can understand that you are saying that confiscating the cell phones had a good impact on the school, and that it does not violate the learner's right to basic education. So now, what about the fact that, what about the punishment or the sanction imposed by the school's code of conduct, which says that you can be suspended for a period of up to 1 year, if I'm not mistaken. So does that not, is that not too harsh, perhaps?
No, my justices.
Okay.
May I continue?
Yes, we are allowed to continue.
Every SGB in the Republic of South Africa must adopt a code of conduct that abides by the South African School Act, number 84 of 1996. This code of conduct must have learners' best interest at heart. Section 8 Code of Conduct provides, number 1, subject to any applicable provincial law, a governing body of a school must adopt a code of conduct for the learners after consultation with both learners and educators of the school. Number 2, a code of conduct referred to in subsection 1 must be aimed at establishing a disciplined, purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. That is why I, the counsel for the respondent, would like to refer to the case law state Province versus Harmony High School, 2013. I refer to paragraph 231, and I quote, "It is not part of the school's governing body's case that its learners' pregnancy policy was adopted as a code of conduct after consultation with learners and parents and educators of the school. In fact, no evidence has been put up to show that it was adopted by the school governing body. itself, despite the fact that the Free State HOD challenged the school governing body in his answering affidavit to produce evidence of a meeting in which this learner pregnancy policy was adopted. The contention that Section 8 gave the school governing body power to issue the learner's pregnancy policy is misplaced. As it pleases the court, I would like my fellow counselor to further my case.
Before your co-counsel continues, I would just like to understand the case that you just referenced. How does that relate to the fact complex as well as your argument in this case?
This was consultation in the case law.
Sorry, counsel, could you please remove your mask? I cannot hear you.
There was a consultation in the case law.
There was a consultation. Are you saying that in this particular case, the law is constitutional or the code of conduct is constitutional because there was a consultation process?
Yes, my justice.
Oh, I understand. And on the note of less restrictive means to accomplish punishment, are you aware of any provision in the Schools Act that imposes a maximum suspension period that schools are allowed to impose on their learners?
May you please repeat the question?
Are you aware of any maximum period of suspension provided for in the Schools Act that a school may impose on a learner as a form of punishment?
Yes.
And what is that maximum period of time?
A week.
A week?
Yes, 7 days.
I see. And how does that work then, considering that the learners in this case have been suspended for a period of a year?
They were aware of the code of conduct, my justices.
Yes, but is the code of conduct in line with the provisions of the Schools Act?
Yes, my justices.
But how can that be, considering that you just told me that the Schools Act provides for a maximum period of suspension for a week?
As the court pleases, can I please consult with my fellow counselor?
Yes, you can go ahead.
My justices, in order to gain a peaceful and disciplined school environment,
Counsel, is that the full extent of your answer?
yes.
Okay, thank you. Your co-counsel may proceed if my fellow justices do not have any questions for you.
Well, I do not have any questions, but I just want to make an observation that I think they are only left with like close to 8 minutes, if I'm not mistaken. Yes, so just be cognizant of time.
Yes, yes. He finished his submissions and moved on to his co-counsel. So I just I'm using my discretion to afford him a little bit of extra time so that he could answer my question.
Okay, thank you.
As it pleases the court, I would like to, may I continue, my justices?
Yes, please proceed.
My justices, the Constitution, Section 36, limitation of the rights provides the importance of the purpose of that limitation. The Code of Conduct is aimed at establishing discipline and peaceful school environment. The Code of Conduct is dedicated to improve the quality and the maintenance of the learning process. That is why some of their rights, the uses of cell phones should be limited, because we have not only do phones have a positive impact on the part on schools, there's also a negative impact, such as cyberbullying, being disruptive in class. I could go on, my justices. So we have to protect our children and limit some of their rights to maintain this peaceful and disciplined school environments. For that reason, we disagree with the statement that Section 4 of the School Code of Conduct is unconstitutional. My justices, in terms of Section 17 of the Constitution, the SGB's decision is not unconstitutional. The reason being, learners did not give notice about their protest whatsoever. That is why I would like to quote Section 3 of the Constitution, notice of gatherings. I quote, "The convener of a gathering shall give notice in writing signed by him or her the intended gathering in accordance with the provisions of this section," end of quote. My justices, I would like to point out the fact that these learners had 2 consecutive gatherings with the crowds growing, with every gathering without any written notice. They blocked the school premises and there was coincidentally an open fire. Was this a coincidence, my justices? I think not. To me, it seems like these children were deliberately threatening the lives of others. My justices, according to Section 17 of the Act of Public Violence of 1996, a person is deemed to have committed the common law offense of incitement to public violence if a person has conducted him or herself in a manner which the reasonable consequence would be the commission of public violence by others. I would like to point out the fact that these 6 learners firstly gathered outside the school, where they were told to leave the school premises, dragging large bins and blocking the street. The next day, 40 other learners joined again. These learners were blocking the entrance of the school. The following morning, there was approximately 100 learners now gathering outside the school. My justices, I would also like to point out that the fire brigade had to be called out twice because these learners ignited a fire by setting the school's bins alight. That is why counsel for the respondent would like to refer to the case law of Mlungwana and others versus S and others 2019. I quote paragraph 43. Section 17 guarantees the right to assemble peacefully and unarmed. The content and the scope of this right must be interpreted generously, but its meaning is clear and unambiguous. The only internal qualifier is that anyone exercising this right must do so peacefully and unarmed, which the applicants did not do. These 6 learners infringed the right to basic education when the entrance of the school, where they violated the other learners' right to Section 29, subsection 1 of the Constitution. And it states that everyone has the right to basic education. They infringed, I repeat, they infringed the 6 learners' right to basic education when they blocked the school. My justices, I come to the conclusion that the manner in which these learners acted was indeed inappropriate. The consequence of their action was that they were inciting others to commit public violence. And we also have to keep in mind, with rights comes responsibilities. Not only did these learners not give a notice, there were disturbance for the motorists that were using the road at the time. The SGB wanted to hold a scheduled meeting with the parents, but unfortunately, because of these protesting learners, that couldn't be possible. I stand by my previous statement that the SGB's decision is in fact not unconstitutional. My justices, the Constitution Section 9 of Equality states that everyone is equal before the law and has the right to equal protection and benefits of the law. In terms of this section, the children did appear in front of the SGB and was put on a disciplinary hearing. The cell phone that was confiscated was more than enough evidence for the suspension of this learner. This specific learner was aware of the code of conduct and chose not to obey, thus inciting other learners to also disobey the code of conduct and challenge authority. In conclusion of my argument, the counsel for the respondent has established that Section 4 of the School Code of Conduct is not unconstitutional and does not violate learners' right to privacy and basic education, as it has been limited, as I have previously said. The SGB's decision is neither unconstitutional, nor does it violate learners' right to peaceful assembly. Counsel for the respondent respectfully prays that this honorable court declares that the counsel for the applicant's claims are indeed incorrect. Respectfully submitted, counsel for the respondent. If my justices do not have any further question, I rest my case.
Counsel, you imply in your submissions that the students are responsible for the arson. In fact, you directly stated that the students set the bins on fire. Is there any evidence indicating that they in fact did so?
Yes, my justices. It has been stated in the hypothetical case that these learners, there was also a fire in the administration block, and they set these bins on fire and they blocked the school entrance. So, which means that it couldn't be a coincidence. There's also a fire at the bins and at the administration block.
Thank you, counsel. Do any of my fellow justices have questions?
No questions from me.
I don't have any question. I think they covered almost all the aspect I wanted them to address. So yeah, for me it's okay.
All right, brilliant. The applicants have reserved 2 minutes for rebuttal. So you may proceed with the rebuttal.
Justice, I would love to respond on a statement that was stated by my honorable friend, saying that the applicants were responsible for the act of arson that took place in the school. When you are referring to page 3 of the hypothetical case, in a sense of vandalism, no culprits were identified. So we cannot crucify the applicants for the acts of vandalism. If there is no evidence that can support that, then we would like to discredit the statement of my honorable friend.
Thank you, counsel. Is that the only point that you wish to rebut?
Yes.
All right, thank you. You still have time left if there's anything else. Otherwise, we can conclude the session.
Let's conclude.
All right, thank you. Okay, so I would like to provide some feedback. We will also be providing feedback in the score sheets. First of all, I would like to congratulate you both on a very persuasive and confident submissions. You clearly are all very skilled at public speaking, and I also want to just congratulate you on a job well done for all the research that you've put into the arguments that you've made.
Yes, I will also just reiterate that, yes, I congratulate both you guys for doing so well. Yes, I was really highly impressed by your arguments. Yes, to see high school students bringing to the table such in-depth and very specific analysis of the law. Yes, I am highly impressed by that, and I am so proud of you guys. And just more from a stylistic suggestions. So when judges ask you guys questions, just remain calm, don't be nervous. Yeah, don't let the nerves get the better of you. And just when you answer, just include a little bit of case law and legislation, and then kind of make it a point that you sum up your answer and bring it back to your main submission. For example, that Section 4 of the school's code of conduct is constitutional or unconstitutional. Just sum it up so that questions are not left hanging in the air. But yes, that's just me. But otherwise, anything else other than that, I'm proud of you guys. You did really well.
Yeah, thank you to the two teams. I think it was a very interesting session. I appreciated the quality of the discussion. To some extent, I was surprised by the confidence of the two teams, and also the ability with which the two teams were able to navigate and use the different legal instruments. I think it's a very good thing. Just please keep it, and I hope to see the two teams at the next stage. It was a very good session, so congratulations again.
All right, thank you. I think the teams that need to appear in the next session are already in the waiting room. So if I could just please kindly ask the teams and the justices who should not be here for the next session to leave the session